Раз, два, три, тест. Слышно ли?
Aynen bu birinci konuda Baltık'taki notariat şartlarında sizlikle yapmış tutarken masalar, notariat toplantısından tutarken masalar, mecbur O'zbekistonda notariat faoliyatlar şovlari shakliga o'tdi. Forum nafaqat O'zbekiston tarixida, balki Markaziy Osiyoda ilk marotaba tashkil etilgan forumlardan biri hisoblanadi. Mana pandemiya sharoiti bo'lishiga qaramasdan, mana bugun biz sizlar bilan yana bor diydorlashib turganimizdan biz xursandmiz. Pandemiya ham bizga to'sqinlik qilmaydi, buni hammamiz yaxshi bilamiz, lekin agar hammamiz yuzma-yuz ko'rishib turganimizda o'ylaymanki, kelgusida bunday tadbirlar amalga oshirish imkonimizda bo'ladi. O'zbekistonda notariatda so'nggi yillarda ko'p o'zgarishlar amalga oshirildi. Ben qisqacha qilib aynan shu o'zgarishlar haqida aytib o'tmoqchiman. Hammamiz yaxshi bilamiz, o'sha prezidentimizning farmoniga asosan Adliya vazirligining tashabbuskorligida.
Yes, you are all aware that in line with the initiative of the Ministry of Justice, the notary services of Uzbekistan are providing private services, and almost all members of the notary are members of the National Association of the Notaries. And to carry out all the activities pertaining to further development of the notary, we also provided the opportunity for accelerated procedures, so you can get the digital number, and which will speed up the process and невозможно реле брать.
Video konferens aloqa rejimida va elektron raqamli imzodan foydalangan holda masofaviy notariat harakatlarini amalga oshirish yo'lga qo'yilmoqda. Aholining elektron murojaatlarini qabul qilish hamda ularga servis xizmatlari ko'rsatish maqsadida veb-saytlar yaratilgan. Bundan amalga oshirishda ham qator o'zgarishlar amalga oshirildi. Ya'ni ko'chmas mulk oldi-sotdisi bilan tasarruf etish bilan bog'liq shartnomalarni yerli bankalarda rasmiylashtirish yo'lga qo'yildi. Bundan tashqari, ko'chmas mulklarni oldi-sotdi, hadya va ayirboshlash shartnomalarini amalga oshirishda hududiylik prinsipi bekor qilindi. Ya'ni hozirgi kunda eksterritorial qonunlar asosida barcha notariuslar tomonidan uy-joylarni tasarruf etish shartnomalari rasmiylashtirilishi mumkin. Bundan tashqari, ko'chmas mulkni boshqa shaxsga o'zgartirish shartnomalari tasdiqlangandan so'ng ularni yagona barcha tamoyil asosida kadastr organidan ro'yxatdan o'tkazish tizimi joriy etildi. Hozirgi kunda vaziyatnoma hamda ayrim murakkab notarial harakatlarni, hatto sayyor tartibda amalga oshiriladigan notarial harakatlarni qonuniy hujjatga imzolash jarayoni majburiy tarzda audio va video yozuvga tushirilmoqda. Xususiy notariuslar faoliyatida hozirgi kunda o'tgan yildan boshlab xususiy amaliyot tashkilotlar o'z faoliyatini boshladi. Hozirda O'zbekistonda 867 nafar xususiy amaliyotdan gumonlanuvchi notariuslar o'z faoliyatini amalga oshirmoqda. Xususiy notariuslarning bu bilan moliyaviy imkoniyatlari mustahkamlab berildi. Jamiyatda notariuslarning faolligi oshdi. Endilikda notarial idoralarda navbat kutish muammosi bartaraf etildi. Notariat sohasida erkin raqobat shakllandi va notariuslar aholiga yangi sifatli xizmatlar ko'rsatishni boshladi. Notariuslar soni ko'payishi natijasida uzoq aholi punktlarida notarial xizmatlarning to'liq joriy etilishiga erishildi. Aholining davlatga ishonchi yana ortadi. Kadrlarni tayyorlash, joy-joyga qo'yish bo'yicha qilinayotgan ishlar bo'yicha hozirgi kunda notariuslarning ishi faoliyatini baholash tizimi joriy etildi. Hozirgi kunda oliy malaka komissiyasiga imtihon topshirish, murojaat qilish faqatgina elektron murojaat qilish tartibi o'rnatildi. Notarius lavozimlariga nomzodlarni tanlov, malaka imtihoni asosida tanlab olish jarayoni real vaqt rejimida video translyatsiya qilinmoqda. Hozirgi kunda bundan tashqari notariuslarning notarial harakatlarini amalga oshirish jarayoni onlayn tarzda monitoring qilish imkoniyati mavjud. Bu bilan yanada sifati va majburiyatining oshishiga olib keladi. Notariuslarning o'z kasbiy faoliyatlarini bog'liq faoliyatini amalga oshirishda. Hozirgi kunda mana biz O'zbekiston Respublikasi Notarial palatasining bu qonunga qo'ygan eng asosiy maqsadlaridan biri Respublika Notarial palatasini xalqaro hamjamiyatda o'z o'rniga ega bo'lishi va bunga birgalikda mana shu hozirda biz xalqaro hamkorlarimiz bilan memorandumlar imzoladik. Xususan aytib o'tadigan bo'lsak, Litva Respublikasi bilan, Belorussiya Respublikasi bilan, Ukraina davlatlari bilan hozirgi qisqa fursat bo'lishiga qaramasdan memorandumlar imzolandi. Va memorandumlar doirasida hozirgi kunda xalqaro tajribalar xalqaro notariuslar tajribasini qo'llash borasida ko'plab qonunlar bo'yicha muzokaralar olib borilmoqda. Bundan tashqari eng asosiy maqsadlarimizdan biri notarial palatani xalqaro notariuslar ittifoqiga a'zo bo'lish masalasi. Hammamiz yaxshi bilamiz, bu borada keng ko'lamli ishlar olib borilmoqda. Xususan notarial vazirligi bilan hamkorlikda bu borada qonun hujjatlariga tegishli tartibda o'zgarishlar va qo'shimchalar kiritib borilmoqda.
Till the year end, it is expected that the Notary Chamber of Uzbekistan will join the International Union of the Notaries. And this year, the pandemic is still with us. And I apologize, but the sound is very bad. So now we are holding the second International Legal Forum, Tashkent Law Spring, and this time among the participants we have the working group. We have with us Mr. Richard Bob, President of the Commission for International Notarial Cooperation of the International Union of Notaries, we have Mr. Korsik, President of the Federal Notary Chamber of the Russian Federation, Mr. Marius Strakaitis, who is the President of the Lithuanian Notaries Chamber, and Mr. Vladimir Marchenko, Chairman of the Notary Chamber of Ukraine.
Janob Bobga, Richard Bobga bermoqchiman. O'sha mavzularni, hujjatlarni elektron saqlash va masofadan turib notarial tasdiqlashning.
We would like to extend our gratitude to our speakers.
Marhamat.
So we are going to discuss a lot of issues related to the activities of the notary. Thank you.
Janob so'z navbati sizga berildi. Marhamat, manzilingizni olamiz.
Mr. Bog, the floor is yours, please.
Okay, okay, good morning, everyone. Dear President Ashurov, dear presidents, dear colleagues, ladies and gentlemen, I thank you very much for the invitation to today's conference. It is a great honor, but also a pleasure to speak to you today and give an overview over the latest developments of our information technology. For some years now, the German Federal Chamber of Notaries has been developing a platform which covers the entire electronic orbit of our profession. The execution of our deeds is already nearly completely digitized. One of our last projects was the creation of a technology for authentic instruments in exclusively electronic form. Moreover, we will also archive our documents electronically within this framework. The electronic document archive of the Federal Chamber will be operational from January next year. From that date onwards, all documents created by notaries will be stored only electronically. A prerequisite for operating an electronic archive is the production of electronic documents. At present, all our documents are produced in paper form. Since we know that it is not possible to order all 7,000 German notaries to forget paper from 2022 onwards, we first had to consider how we could continue to convert still admissible paper documents into electronic documents for a transitional period. During this period, an electronic version will be produced immediately after the authentication. It is legally equivalent to the paper document. The paper must therefore be scanned, and the scan must be qualified electronically signed. As we know, security gaps can arise during scanning. Our IT department has developed a scanning process that eliminates such gaps. Only standardized scanners in conjunction with specially developed software are approved for this process. The notary will then store the scanned version in his electronic collection of documents. This collection will be kept exclusively in the document archive of the Federal Chamber. This archive is highly secure. The data is not stored in the cloud. This is very important. We don't use the cloud. We are currently setting up 2 independent data centers in Germany where all data is archived in parallel. What will access to the archive look like? The archive must be imagined as a system of lockers at the post office or at a railway station. Every notary has the key to a locker that is only accessible to him. Persons other than the notary have no right of access. Also, the metadata, it is the table of contents, for instance, the name index, etc., can only be searched by the notary to whom the electronic deposit box belongs. The data is encrypted in such a way that a search by the archiving authority, this is the Federal Chamber, or any other state authority is not possible. After the notary leaves office, the notary's access authorization is transferred to his successor in office. What does the security architecture of the archive look like? The electronic document archive comprises a digital space that extends from the computer centers of the Federal Chamber to the 7,000 notaries' offices. The local entry point into the system will be the so-called archive box, which will be set up in each office. The archive box shields the archive from the internet. In addition, the box will perform cryptographic functions needed to create the electronic version of the original document. They serve to ensure data security and preserve the probative value of the document. You will now perhaps ask me how we are proceeding with the development of a technology for original electronic deeds. Original electronic deeds. In some countries, such a practice already exists. If we answer these questions with regard to the normal case in our practice, namely presence authentication, electronic procedures should be relatively easy to establish. The basic parameters of the authentication procedure are not affected. The notary continues to investigate the will of the parties, drafts the deed, reads it out in presence of the parties from a screen, not from the paper, from a screen, and the handwritten signatures will be replaced by qualified electronic signatures. Nothing else will be changed. The main problem with electronic authentication procedures arises when the parties are not present in person, but are to be connected via screen from a location outside the office. In some countries, such distance authentications are already practiced via Skype, Zoom, or FaceTime. In our view, these procedures are not safe. They endanger the probative value of the deed and are not suitable as a basis for entries in the state registers that enjoy public faith in our country. Within the framework of the implementation of a new EU directive on the digital formation of companies, our IT department has developed a procedure that enables high-quality remote authentication. Besides data security, the other main parameter of our development was that our tool is easy and user-friendly to use. It is already available as a prototype for the formation of companies, but it is technically possible to use the whole procedure for all parts of notarization. In Germany, notaries play an important role in company law. The articles of association of a limited liability company must be mandatorily authenticated by a notary, and it is also only the notary who is technically and legally authorized to submit the applications for registration to the commercial register. Such an online system must be absolutely tamper-proof. For this reason, a particularly secure double identity check is carried out by reading out and verifying both the data and the image of the EID. To our knowledge, this is a unique process which has not been used elsewhere in the world so far. The system is a one-stop shop offering all functions necessary for the formation of a company. It is designed in a way that citizens only need a laptop with a camera, microphone, and an internet connection, as well as a standard smartphone to proceed. Additional hard or software is not required. The online formation can be completed in 5 simple steps. In the first step, the citizens register in the portal set up specifically for this purpose. To register, they identify themselves via their EID, such as the online identification function of the German identity card. Foreign EIDs are also accepted if they have been notified according to the EIDAS regulation. This is a German ID regulation. European ID regulation. The citizens simply use their smartphones for identification by scanning the QR code. The QR code is to be found on the website of the Federal Chamber. By scanning this code, the application of the Bundesnotarkammer opens and leads the citizen through the identification process. When holding the EID on the smartphone, the application can read out the data stored in the ID safely and contactless. To this end, NFC technology is used, as in case of contactless payment via credit card. You know this technique if you pay in the supermarket, for instance, by your smartphone. The smartphone thus serves as a card reader for the EID. Since the content of the document can no longer be signed by hand during online authentication, each party needs a qualified electronic signature that can be affixed to the deed. Therefore, based on the data read out via smartphone, a qualified electronic signature is immediately generated. The Federal Chamber has its own certification authority authorized to issue such qualified electronic signatures. The citizen receives the electronic signature as well as a multi-digit code called 10. I think you know these 10 codes. That is sent to the smartphone and allows them to activate the electronic signature at a later stage. Following these preliminary steps, the citizen can choose a notary via the portal in a second step and already make an appointment. In a third step, information regarding the planned company formation, such as shareholders, directors, etc., can be entered in an input mask. The information is transferred to the notary. On the basis of this data, the notary prepares the draft. It is safely sent to the parties via the portal. The fifth and final step is the authentication. For this purpose, all parties log in to a video conference. The parties use again their EID and smartphone, which reads out the data stored in the EID. Additionally, and this is unique on a global scale, also the image stored on the EID can directly be read out electronically, which allows the notary to compare the person in the video chat with the owner of the EID. This is much safer than merely taking a picture of the EID or holding it up to the camera, as the image on the identity cannot be manipulated so easily. The notary then reads the document to the parties, explains the content, and answers the parties' questions. To this end, the document is shared via the share screen function. Finally, the contract is digitally signed, which means the qualified electronic signatures are being affixed. It's quite simple for the citizen, since his signature was already created at the beginning of the process, as I mentioned before. When the citizens want to affix the signature, they only have to enter the 10 they have received on the smartphone. When entering the 10, the qualified electronic signature is affixed and the document is signed. These 5 steps allow a simple online formation that meets the highest security requirements. Furthermore, the following 4 aspects make the system uniquely secure and very clear. First, the system is developed and operated solely by the Federal Chamber. Second, the citizens can identify themselves with their EID and smartphone and qualified electronic signature. Third, the fact that also the digital image of the EID is read out during the authentication ensures a double identification that is particularly important. Fourth, by simply entering a 10, the citizen can digitally sign the document. I come to an end now. We all know that we cannot and will not close our minds to new developments. However, in the digitization project, we must not lose sight of the purpose of our profession and the tasks it involves. It is our legal mandate to guarantee the security and reliability of economic transactions and the shaping of social relations. To this end, it is necessary to design our working environment in the best possible way with regard to security and reliability. The work processes in the notary's office must comply with the highest technical standards from the first contact with the client to the execution of the deeds in the register. Our profession thrives on the trust of both citizens and state institutions. Errors and gaps in the security architecture of our electronic systems, as we regularly experience in the payment transactions, would not be forgiven for our profession. That's why we have developed our IT ourselves with the highest level of technological expertise and the greatest possible care, thus meeting all requirements for a high degree of functionality and optimized transparency. These parameters of our IT development correspond exactly to the two relevant principles on which notaries base the design of their deeds. This is optimized functionality and maximum security for the professionals and all parties involved. Thank you for
işonchliligini qilaman. Janob Marius. So'z navbati sizga.
Mr. Marius, the floor goes to you. Esteemed colleagues, good morning. Unfortunately, pandemic has not allowed us to get together and to share beautiful news amongst us. But the pandemic is the way of life that we conduct for 2 years already almost, and we were stopping at the doorsteps for quite a period of time, and we were unable to go beyond that door. So I'm talking about distance notary services. Notary services of Lithuania, we have a very good news. In March current year, our parliament has adopted the amendment to the law on notariates, which has provided the legal provision for the notary actions without the presence of the client, and with the help of quite reliable distance means and features. Currently, we only have 2 months to get prepared to perform notary services using remote opportunity and capabilities. So from 1st of July, current year. So being an authorized person under pandemics, still, we have to continue providing the population with very important public services. Lack of opportunities to perform notary actions. So if it's not possible to do remotely, we have to find our ways. So for notary services, provision of services remotely has become quite an urgent matter. In autumn last year, sociological poll has been conducted in September 2020, and 51% of inhabitants of Lithuania quite positively assessed the possibility to legalize distanced or remote notary services. In my report, I'll go back to these actions, but to start with, I'd like to provide for a brief overview down to the beginning of the remote notariate. So I may say that within 2 decades, we cannot even imagine our life without digitalizing and without collaborating with electronic registry. The responsible person for that to establish, the registries, the state is responsible for that. So the absolute majority of all registries is supported and ran by the state enterprise, public enterprise, Center of Registries. And the state is not only the consumer of this registry, but also is the supplier of all the data to the registry. So they introduce to the registry all the needed data. So the client, upon addressing to, let's say, certain lawyer, for example, if you applied to get the letter of attorney, so you can register it there and it's electronically registered. So you, in the case if you are trying to address to a different lawyer, you just locate or pass on this registry. Besides, all other documents are being downloaded, like a prenuptial contract for the copy, for example, is being also downloaded to the registry for prenups. So as for the actions of notary, we have to be faced with several number of registries, and by law, we have to be in compliance with all of them. So I'd like to remind you on the most important ones. So the registry of the population, so the notary officer checks upon those data, let's say the credentials of the person, and can check for the relatives of the person. So those incapacitated persons are also entered to the registry. So the notary officer can check if the person is really incapacitated. So as for the property, as for the different types of properties, to check to understand if the person is trying to submit certain property. So there is another instrument working with the notary service when notary officer have to approve the changes in the charters of legal entities, etc. The most active, I think, and the most useful, that's the registry of public services with regard to the property. From July 2009, this electronic area, so with regard to real estate, when we're talking about registration of real estate, we may say that this service that has become a startup of having this electronic notary service. In order to have deals or transactions done with regard to real estate, we may turn into the system. We start to look for registry data on the sites of real estate, and with the help of templates which are saved there, we may fill out our own agreements. And based on my own experience, I may say that this part of work of notary service was quite revolutionary, because we were able to avoid errors and mistakes. You know, when we were previously doing all these agreements manually, every time we would make mistakes and typos. Transfer of data electronically is done automatically, and that's very useful. The agreements which has been developed electronically, notary officer will print them and gives this to parties for signature, and then it covers it and approves with the stamp. Then electronic signature of the notary officer is also applied, and the document is sent to the database. Similarly, all the data about the deals and transactions are being passed on to the registry to pass on the title as well. The functioning of this public electronic service for real estate transactions has been so successful that after the law has been adopted on the mortgage reform, and it was done in July 2012. So from the moment of putting into force this reform, notary services and notary offices do register all these deals and transactions online. So recent 10 years showed that the development is quite rapid. So at the same time, we were able to improve the protection system and legality, and also distance system of identifying and recognition system has been applied. So we have become a initiator of establishing a self-sufficient system. So we thought that at least part of the documents could be done electronically. But we could not even imagine that on the current situation, we will be able to develop opportunities for remote actions and remote notary actions. Majority notary services of the whole world have already established their own electronic notary services. So, and the main concern of our notary service of the Roman type to be reliable and to be able to identify remotely the facial features of a person, and to be able to identify the person, and only then to follow on with proper actions. Also to provide security, which means that if we apply technologies in our work, the priority will be to provide for legality and legal safety and authenticity. So the philosophy that goes beyond our notary, so of course remote actions within notary service is not a surrogate, it's just an additional function. So it is a lot easier for the client sometimes to obtain the service from the notary service. But if the notary officer has certain doubts with regard to the personality or identification of the person addressed, then immediately he or she will invite this person for the offline meeting. As for information system in Lithuania, we've started that work in 2014, and it was finalized in the beginning of 2017. Within 3 more years, we developed a service for the website of State Center for Registries, and we were agreeing on specification, and we were doing integration among the systems. So as for our neighboring countries, Latvia and Estonia, then I may say that those countries are several steps ahead of us. In Latvia, for example, starting from 1st July of 2018, they have this great opportunity to resolve notary services, notary actions online, remotely. And in Estonia, the law on that matter last year they have adopted.
Министр юстиции после создания информационной системы
1st of April 2020. In both countries, the state is actively supporting all these processes. So in
таким способом было еще не обязательно. А с начала этого года все нотариусы своей реальной деятельности обязаны уже пользоваться этой системой при заполнении реестра электронным. В соответствии с принятыми в марте поправками, нотариус дистанционным способом сможет выполнить все нотариальные действия за исключением удостоверения лица в живых и
certificate of inherited property
официальным завещанием и
and adopting for
способ совершения
we are identifying the living persons in certain area.
Они проводятся по одинаковому.
Then notary actions, both remotely and offline, they deem to be equal. Besides,
Это значит, что
legal consequences will be also similar, which means that
будет обладать такой же силой, что и нотариально заверенный бумажный документ. Нотариус будет вправе не совершать нотариальное действие дистанционным путем, если у нотариуса возникнут сомнения относительно надежности идентификации личности. Существует высокий риск с учетом целей.
Taking into account the objective of the deal or transaction which the client wished to have and the amount of
Третье, по мнению нотариуса, в ходе
total amount of the
было бы лучше
for example, the
разъяснение сути последствия совершаемых нотариальных действий. Решение нотариуса не совершать действия дистанционным способом обжалованию подлежать.
Opinion of the notary officer
электронный нотариат, предназначенный для клиентов, будет
electronic notary service will be accessible both from desktop computers but also from the cell phones. In order to enter from the external portal, the identification of the person will be done with the help of a special service. So there is a banking system of authentication, and also there is an electronic system of authentication. So should there be a specialized scanner to have recognition system installed? For primary, we will have to develop a registration registry. So we will have to provide for the registering of the services. The visit to notary will be virtual. With the help of, we'd like to share with you right now, and the most important is that amongst our notary services is proper identification of a person. As it was mentioned already at the first stage, the recognition of the facial features is being established by the established service. Another thing is visual comparison of picture with the identification document. So to be clear that the person has hooked in remotely. So it can be done both by the notary officer, but also using automatic platform of personal identification. So the client at the platform makes his own picture from both sides of the document, and then at the platform they do comparison of the client's facial features to identify, and then it compared with the features in the document which has been already previously downloaded. So then the final decision is made by the notary officer, and he's led by the image and the approval of the platform. Should there be any doubts with regard of the authenticity of the face, then the notary officer may require meeting in person. So electronic documents which are being approved, qualified electronic signature is being used. After approving the document, authorizing the document, the document will be automatically sent to the client, to that external portal of the system. The client will be provided
with the files in the format PDF and ADOC. So payment can be effected using most up-to-date techniques via bank transfer or by using a card, and over a distance. A notary can effect notary actions not only for persons residing in Lithuania, but also for persons abroad, but only for citizens of Lithuania. Thus, these actions will be carried out, meaning that identification can be carried out against the database available to our services, and that's why IDs issued by foreign countries cannot be used, because we can't carry out any checks. One thing is to devise a new digitization project and to translate it into practice. A totally different point is to change the people's mindset. The pandemic has considerably broadened the computer literacy of people and also their understanding of digital service delivery. And we do know at the Lithuanian Chamber of Notaries that over the pandemic period, the need has increased for digital services. We are aware of that, but roughly 9 out of 10 notary actions are carried out traditionally by a notary office. And remote notary actions mostly are used by younger, dynamic business people. On the other hand, My colleague, the chair of the Notary Chamber of Latvia, informed me that he personally carried out notary actions for an 80-year-old lady, and she was very computer literate from the technological standpoint. And notable issues faced by our neighbors suggest that most of the population do not make use of digital documents, and seemingly in Latvia, the first digital client will be the younger people, representatives of businesses, and obviously Lithuanian residents residing abroad. But hopefully, the electronic notary will be a valuable mechanism, making it possible to come up with the digital environment, which will be more reliable and safer. Thank you very much for your attention. In case you have any questions, I will be happy to answer. Thank you, Mr. Marius. So it's a very important aspect in terms of identification of a person and notary activities, because the digital approach used by notaries for identification of persons, well, we do understand that any document is related to a real person, his life. And now the floor is given to the President of the Federal Notary Chamber of the Russian Federation, Mr. Korsik. He will make a presentation on digital notary of Russia, achievements and prospects. So he was active, and during the first forum, Tashkent Law Spring in 2019, we perfectly remember him, and we are pleased to see him once again at our platform. Good afternoon, dear colleagues. First of all, I'd like to extend my sincere gratitude to the organizers of Tashkent Law Spring for this invitation. In fact, it is a very good opportunity to meet you once again, unfortunately, in the online format, to meet all the colleagues I'm happy to see. Now, I will share some of the updates on the Russian notary, namely on our experience in using and developing digital technology in the notarial activities. And notary in Russia is one of the key enforcement institutions. So we have some 8,000 notaries in our country, and it's turned the legislation for several years has been pursuing the goal to expand the powers of notaries in addition to traditional competences like processing the rights pertaining to bequests and others. Now notaries enjoy broader powers in terms of corporate relations, and of principal importance is that in recent years we got decisions recognizing the enforcement powers of notarial decisions, and advanced digital technology underlies many notarial actions, and they actively introduced them into their practices in recent years. So as the project electronic notary, now we are providing the authentication of documents, confirming its equivalence to paper-based documents. And now citizens via notaries can approach government agencies, other companies to submit documents nationwide in the vast area of the Russian Federation. And so millions of such actions are carried out. in our country. At the same time, we are seeing that IT technology is involved in almost any notary action, and the notaries have become the leaders in terms of the implementation of digital technology into their activities. And in Russia, the notaries have their own digital infrastructure, which makes it possible to ensure safety and reliability of legal relations, also in the settings of digital workflows. And the core of that is the digital notary system, which was established by the Federal Notary Chamber in 2014. And soon it will celebrate its 7th anniversary. So notary funded it on their own without any state subsidies as compared to our colleagues in neighboring countries. It all was mandated to the notary community, so we fund it on our own. We are developing our information system, and currently in the unified information system, we register absolutely all notary actions. So scans of all notary documents go to the integrated information system, which makes it possible to protect the notary deeds and acts, and which makes it possible to authenticate legally important notary actions. The integrated information system serves as the core for cooperation between notaries and banks, other organizations using state registers. And thanks to participation of notaries in the interagency electronic interaction system, so the Russian notary offices became the real front offices for registration agencies by filing notarial requests. Notaries check a lot of information. Thanks to digital interactions, such checks are most accurate and timely. In addition, each Russian notary has the enhanced qualified digital signature, and the legislators also can come up with the option without paper-based options. For example, electronic letters of attorney are now accepted by our organizations, and it serves also to ensure safe online servers. It operates 24/7. The register providing information on collaterals against movables, and then the service to search for cases related to bequests, and such services are in high demand among residents and citizens and other, because legally important information can be verified thanks to them. Colleagues, we are seeing that the Russian notary is experiencing another wave of digitalization. And the first step, the so-called digitization, is over, and the second step envisages remote actions. Some of actions can be effected remotely. So totally new formats for approaching a notary are possible, remote and distance. So the remote format makes it possible to approach a notary for a notarial action, and which documents the expression of a will, which doesn't require any verification or verification of facts. And using a computer, you can approach a notary for such actions, meaning the actions where you need an abstract from the register, or when you need a notary writ of execution or executory endorsement, and then you can receive the documents for deposit, verification of documents, and a number of others. But as for distance format for verifying of transactions, so it's an effective tool when parties cannot meet in the same notary office or don't want to. And then the shared complete responsibility is placed on notaries. And in any case, I guess we are more conservative compared to our colleagues from European countries. So that's our approach to introduction of IT and distance actions. In this case, a visit to a notary is mandatory, but each party can come to a specific notary. For example, we had the transactions when one party comes to a Moscow notary, the other to the Yuzhno-Sakhalinsk notary, and then the transaction is effected when one of the notaries submits it for registration. And the notaries now are entitled to use the register of biometric data for identification of the applicant, and the applicants also could be identified using the enhanced qualified digital signature. And another innovation which is significant is that the paper-based documents now have the machine-readable markings or labels, and any person who wants to scan it using the smartphone camera also can verify the authenticity of a notarial document, let alone the fact that all these documents are placed in the shared electronic space of the notary. Thus, we can identify forged documents, and we contribute to verification of reliability of all documents processed by the notary. Now we are also actively interacting with the state portal, and we have the project of super services where we integrated various services, and also we make use of digital interaction with many ministries and agencies, providing comfortable conditions for citizens. So a citizen can come to a notary only once, and then the rest all documents in digital format are submitted to all other relevant ministries and agencies. And for example, a bequest of funds could be obtained by a resident via the bank without personal visit. Another project is the opportunity to search for documents left by estate leavers, and then it's also about searching for bank deposits, and this serves as the impetus to further development of initiatives required for the civil relations and technological opportunities for submitting digital documents from individuals and legal entities could be also maintained using the servers, and it also offers opportunities for remote notary actions in its turn. The principle of distance authentication of a deed using 2 or more notaries could be used to verify results of corporate meetings of legal entities, and such draft law is already available and submitted to the State Duma. Also, we have a draft law which envisages adding new entries to the register of cancelled letters of attorneys compiled electronically. So on top of our register, we are maintaining about withdrawal or cancellation of letters of attorneys. I guess we can be mandated with maintenance of old portal for withdrawn or cancelled letters of attorneys. So the first draft has already been approved, and now we are discussing establishment of the shared register for legally important messages, notifications, and the Federal Notary Chamber also suggests using the capacity of notaries to work with video conferences and authentication and verification of their results, and as part of the broadly discussed today system of smart contracts. We can also work with relevant parties. So this is required when we are discussing transactions engaging citizens. It's important to highlight that the total digitalization related to streamlining and acceleration of all procedures also has negative effects in terms of stability and security of legal relations, because information technology become the core of new fraudulent schemes aimed at stealing other people's properties. And the digital environment has a lot of risks, which has repeatedly been mentioned by digital experts, because the computer system can't really check the real will of parties, can't make sure their actions are voluntary. And the streamlined procedure and immediate decisions in digital environment make citizens more vulnerable. First of all, the people who are not ready from the technological and legal standpoints. And it means that there is a risk also for digitally savvy persons, because sometimes they don't even think about legal sense of the pop-up text on their screens, and they don't find it necessary to understand it. So actually, they believe that all documents they see on their computer do not mean any risks to them. In fact, this is not really true, because the security of the actions which cannot be provided by computer systems has always been provided by the notary, because they act as guarantors of the legality of documents and further opportunities for appealing against such decisions. And so these measures can also provide added security to the actions. Also, when we work with the register of real estate. And as for our technological developments, we are actively being transformed. And the key point is that we are just blindly following the digital trends, but we also make every effort to effectively carry out the tasks mandated to us by the government. Once again, I would like to highlight that the digital technology elsewhere is becoming part of the life of the Russian notary. But as for introduction of IT to notarization, well, our approach is very conservative, and in this case, to effect a transaction, the visit to a notary in Russia is mandatory. And definitely, we are taking into account experience of our foreign colleagues. And of course, later on, we will implement this technology. However, the Russian legal system here is quite conservative, but that conservatism is necessitated by the need to protect our citizens, because first of all, we have to act as guarantors of stability, and we have to ensure security. As a result, given the developing digital economy, the notary is willing to provide citizens and businesses the most up-to-date services. We keep track of those tendencies, of those trends, and I guess we will also adopt experience of our colleagues and share our experience as well. Thank you once again for an opportunity to see you all, to meet you online, and I guess our next Tashkent Spring will be held offline. Thank you so very much. Thank you, Mr. Korsik, for such an informative presentation. We also do hope so that we will be able to see all our colleagues.
Ukrainian Notary Chamber. Mr. Marchin, I'd like to say that up to date we've signed a memorandum of understanding and collaboration with Ukrainian Notary Chamber, and it foresees not only the exchange of experience, but also we foresee specific activities to improve their services and building capacity for the experts of notary service to have joined training courses and also sports competitions. So we are very thankful to our colleagues from Ukraine, because we know that there is a healthy spirit and healthy body. So as for the electronic system in Ukraine, yes, the introduction of that, please, the floor is yours. No sound. Esteemed Mr. Marchenko, my apology, but we cannot hear you. No.
Раз. Слышно сейчас?
Да, вас очень хорошо слышно, да.
О, спасибо. Я извиняюсь, тут что-то с техникой
Страшного,
немножко
мы
куда-то
понимаем, это
переключилось.
Все нормально.
Еще раз тогда добрый день.
Once again, good afternoon. It is my pleasure to be invited as a speaker for such an important forum with so many colleagues. It is very interesting and also my great pleasure to listen and to see my colleagues. Unfortunately, we're unable to see each other offline due to pandemics, but I truly hope that within a short period of time we will be able to shake hands and communicate, offline or live communication is always better. And while working with clients in reality is always better than digital notary services, but without digital notary services, we do not have any perspective. We don't foresee them anymore. Well, starting my report, I'd like to emphasize that notary service, that's the leading institution to protect rights and freedoms and liberties of citizens, nationals, and legal entities. So we work with private property and of course, all the changes and reforms in notary service are also linked to changes in the whole country. One of the base reforms in Ukraine is digitalization. So that's why the notary service truly have to become digitalized. So the reforms in Ukraine with regard to notary service has the following areas to complete. Right now, we are initiating the whole full-fledged reform in notary service. So within the time when notary service has been established in Ukraine, there are always changes going on, but the reforms which are ongoing right now can be quite similar to the reform of 1993, when communists have introduced private notary services. So there are three main areas of importance. First of all, it is reliability. Number two, a high level of professionalism and accessibility of notary services for business and population. Current reform foresees following strategic areas: implementation of electronic system of notary service, and I will cover that in particular. Number two, switching to a unified or single notary service in Ukraine. We are still having public and also notary service and also private notary service. So we are oriented and we work with socially vulnerable population. Хорошо, я не матерюсь активно. So the transfer should become quite soft. Number three, it is self-regulation of the notary profession. Right now, Notary Chamber of Ukraine is the organization of self-governance, but taking into account the principles of Roman notary service and switching to the single or unified notary, we have to transfer a number of authorities to Notary Chamber, in particular to control the activity and to follow the code of ethics, to build capacity, etc. Notary Chamber of Ukraine has all the opportunities to do that. But the most important thing is the population is confident, and also Ministry for Justice is quite confident. Self-regulation has been started already, in particular. The High Qualification Commission of Notary Service is now revisited. We have 11 notary officers and 3 representatives of Ministry for Justice. Before it was 7 plus 7. Besides, the commission right now is being headed by notary officer. So control, accountability, and responsibility for the decisions made by the commission is passed to the notary society. State understands that notary officer is economically reliable human rights defender because for the activity of notary services, public budget is not spent at all. So to spend certain amount of funds for judiciary service and many other services, well, it costs a lot more than to spend for notary service. So, and that has been proven already. So we will be implementing the number of reforms, and it has been already agreed both at the executive level and also at the legal branch. So that's the perform mediation, to authorize marriages, etc. Notary service for several years has authority to register real estate and business. So, and we've shown our competency level. So, one-stop shop. So, starting from 2012, notary services has been provided with a high level of authority. So, and also legal to register private entrepreneurs and legal entities and societies. The notary office not only have the access to public or state registry, no, it is an additional function. State registration in Ukraine is being done only by notary service and public or state registry. So Notary of Ukraine has 2 parts of authority or mandate to perform notary actions and to perform state registration as well. At the same time, the notary officer performs state registration and those property rights, the registration of which that has been done before January 1, 2013. Besides other registration as the real estate as the result of having transactional deal, but also in the newly built, newly constructed apartment houses. So notary has truly privileged in comparing with state registration. So for citizens, it is reliability, transparency, and the rights of protection. We minimize the number of instances to get different certificates. Right now, the client don't even have to leave notary office. Why it is another reason why it is a lot better for the population, for the people. So to prevent the violation of rights and interests, we check all the information on the document, and we provide we verify the proper introduction of authentic data to the registry, to all the registries which are in existence. Besides, notary certificate is given within 2 hours even, to provide for proper level of protection. So as for the quality, of course, since the services are provided at a very high level of professionalism, then the registries are being provided with all the information at the very high level. We're talking about fingerprints and many other features, and the software is being upgraded. So the notary service of Ukraine to perform all the actions properly. So as for e-notarian, notary service. We call it Made in Ukraine. Draft law to introduce amendments to notary service has been developed by a joint working group, Notary Service and the Ministry for Justice. Right now, we are finalizing the text of it, and quite soon we will submit it to the Supreme Rada of Ukraine as soon as the active area of quarantine lockdown will be removed. Right now, today, 13 provinces of Ukraine has been announced for lockdown because it's a red zone. So as for the changes into the notary process, again, I've told you we've switched to the status of self-regulation. So first we have to switch from self-management to self-regulation, and then we will meet modern realities. So one of the reforms, that's to introduce e-notariate, and also electronic database has been established in order to optimize the data collection. So the safety is provided by the government, but participation in developing software, and the chamber will participate in that. So in the working office of notary, archives, and then implementation of all the objectives of notary chamber will be there as well. So electronic registry of notary services will cover the whole list of activities that we have right now, and the main thing is there will be the deed or the law or regulation on automatic exchange of data with other entities. So the software will verify the actions, and then automatically our actions will be registered, so without interference of human factor. Under the sector of there will be data kept about the persons who has addressed themselves to notary service based on criteria. While introducing the data, the system will be automatically perform identification of the subject based on the criteria throughout all the database. If you selected the action, then there will be list provided with all the actions, and then all the templates are being provided. So automated checkups and verification steps will be performed. Section of type of notary actions will provide a drop-out menu with regard to the actions to be performed on the documents that has been produced, scanned information, and many other types of information depending on the type of notary action. Besides, that section will foresee also the selection of nomenclature folder. So as a result of notary action, automatically there will be an invoice generated on performing financial monitoring when needed. So the notary officer will send some documents to the State Financial Service of Ukraine. Besides, there will be verification against sanctioned lists, number of databases and registries with which there will be sharing of information automatically. So there will be the majority of them, and of course there will be an opportunity to integrate new ones. In particular, right now, these are the following registries and databases, like State Registry of the Rights for Real Estate, State Registry of Application of Movable Estate, Registry of Legal Entities, and many others. There are more than 20 state registries which are important while performing notary actions, and those which are requesting certain verification and checkups and also exclude any printed media to interfere. So as I told you before, practically we do not have any type of there is no need actually for our client, for our national, to leave notary office and bring back certain certificates or paper certificates. The only thing is needed is the ID, and if we're discussing, So all the electronic forms are equal to printed IDs, for example, but we think that notary officer should also work with documents sometimes, and all paper documents are only needed for some part of documentation. When we talk about subtraction or disposition of rights, for example. So notary templates, they are also electronically done. Those which we are developing, it will be covered by the registry of notary services, and we think they will be integrated by the registry of having notary services, of performing notary services, because I don't think that we have to have more registries, which has been already developed based on the notary service registry. Next, electronic and notary archive. That's the title for that belongs to the state. So, and the results of automatic verifications and checkups will be provided. As for the archives, now the notary officer will not have to duplicate certain actions in different media. So you don't have to carry on with alphabetic logs, etc. That will expedite the work of notary service, will allow to release a lot of space from those printed archives. Searching information through the archives, it will be done based on different criteria: alphabet, data, type of notary service, etc. This data will be automatically distributed to specialized folders, nomenclature folders, and when needed, the verification will be done, and system will remind to move certain items or to remove certain items because the storage period is expired, for example. So besides, there will be separate folders for each and every action. So a number of folders will be developed by the notary service themselves. So all other documents will be checked and verified with different archives in online mode. So the working place of notary officer, that's third section. So that will be the office and statistics and building capacity as well, and certification of the job place, working place. The notary office should be filled out by the notary officer himself based on, and as for location, and then there is an opportunity to download image, to give reference for geographic location, and also information on the days off, etc. Then reminder for the notary officer to submit his or her report. Then also business communication with public official bodies, and also to pay taxes, etc., etc. Information from the virtual office will be renewed immediately, and the notary chamber of Ukraine will follow up with that. Since identification of notary officers is done by qualified electronic signature,
so reports received and the notary office scans of documents, electronic documents, are considered to be as those received as part of the due process, and there is no need to send the printed copies. So written notifications, time of ID are kept in the system, and they can be archived in case of needed and retrieved subsequently. And we also plan to grant access to the system to assistant notaries given the labor agreement and qualified electronic system within the powers established by the law. And the notary platform will include the following parts: the information about emergency notifications and others, and also there could be the option to document the name, last name, address of the notary who reported the message, and also ask for the cases of bequest. Then, when the case is open, the notification is generated. In case of needed, the notary also can place a message that the heirs are looked for, and the database is available and should be placed at the national resource, a national host. And also the integrated database of legal documents, of laws and bylaws about the notary activities, and also generalized recommendations of the notary chamber will also be available there. Then methodological recommendations about notary actions. The rights, the templates of applications, claims, and others, and an opportunity to inform the notary chamber in case the notary rights are violated and the competent support is required, and plus a list of legal counsel you can approach for protection. And the last section is about taxes and taxation for notaries. Document management and statistics. That part makes it possible to generate statistical reports against selected criteria and their automatic submission to those requesting them. Ministry of Justice, Pension Fund, and others. And then the reports electronically come to the notaries. And then the reminders to submit a report are also placed in the personal account of a notary. And plus, we have a section serving as the main platform for quality controls and professional development of notaries. And the account of a notary also contains relevant certificates in case that's needed. The certificate confirming professional competences could be printed, and then the notary also can submit the scans of relevant documents to the chamber, and in case that's needed. Plus, in case the office has to be certified, the relevant documents are generated as well, and such information is also stored at the notary's office. In case of online certification, then the notary chamber retains the right to perform physical inspection of the office. In case needed, it could be done without the notification of the notary. In case inconsistencies are identified, the notary's activities are suspended until the premises match the requirements. Plus, the system also envisages a separate platform to carry out the objectives as specified in the Charter of the Notary Chamber of Ukraine, where we work out all the specifics due to the pandemic as well, and also an opportunity for managerial processes, for management processes to be carried out. And also there should be ongoing protection in case of some contingencies to be provided for notaries. And overall, the notarial reform, first of all, is considered to be beneficial for people. So its implementation will make it possible to save time and money of people and businesses, and to make notarial actions more accessible, to protect against fraud. It will also mean tangible savings for the state budget and an opportunity to switch to the international standards of Latin notaries. And in addition, we are considering such aspects as maximum implementation of notarial functions using the capacity and administrative services the state currently provides to our citizens. The philosophy of our current president is the state in the smartphone. But since notaries in Ukraine are their number is a little bit higher, but we have some 6,800 notaries, 6,800, and the specifics is that currently at least so far, we are the only legal profession providing free of charge legal consultations, legal advice. Other lawyers, other members of the legal profession, they provide free advice only as part of free legal aid subsidized by the state, but we provide it free of charge. We charge only for notary actions conducted. So in addition to a possibility of selected administrative actions like issuing ID cards, driver's licenses, and so on. So if it is added, then it will be it will help promote our profession, and then citizens can get real legal support and consultations. And in fact, they will help him understand what he wants and what he doesn't really want. Plus, when we add such issues, well, so far we can at least make the state to transfer part of the fee to be collected by the notary, because in fact this is not really what it's supposed to be, but it means that we retain such a profession as a notary, but since more authorities and functions could be added, and given the switch to digitalization, that profession becomes stable, because no one can do without that, because no other profession can offer an equal level of quality and stability. I guess my presentation was a little bit longer than expected, but first of all, I would like to wish all the participants of this event, first of all, health, because each notary chamber, being or not being a member of the International Union of Latin Notaries, well, I wish your plans are implemented. I wish the society always appreciates our efforts. Thank you for your opinion. Thank you for such an informative presentation. Thank you so very much. Now we have very limited time, and the floor is given to Mr. Malberti, and he will discuss the instructions of the International Union of Notaries for distance notarization, and he's also the head of the International Council. So the floor is yours.
Dear President, dear colleagues, ladies and gentlemen, thank you very much for your warm welcome.
Спасибо большое за теплое приветствие. Для меня большая честь и личное удовольствие находиться с вами на этой встрече и представлять Международный союз нотариусов. И прежде всего, мне хотелось бы передать вам приветствие от нашего президента и
with the chairperson of the working group New Technologies in the Union, and who I'm here representing today. Please also let me tell you that the Union devotes the utmost care in the admission process of new notariats in view of ensuring the quality and reputation of the notarial profession across jurisdiction. In my presentation, I will introduce you to the
юрисдикциях, и я вам расскажу
guidance on remote notarial authentication,
об инструкциях в отношении удаленных функций
essentially deal with four different topics.
Мы поговорим с вами о разных темах в отношении применения новых технологий, о том, как работают данные инструкции.
These 10 guidelines are divided in four main areas. These are the identification by the notary, how the notary can verify the free expression of will by the parties, and how to ensure that the data is securely stored. Then the guidance discussed the problem of territorial competence, which is a key issue both within national notariats. If in a national notariat you have regional competencies, but also at the international level, because clearly these new technologies would allow theoretically notaries to pass notarial instruments with persons that are not even placed in the same jurisdiction where the notary is located. And the last part of these guidelines discusses the way notaries practically proceed with the signature of the instrument, something that to some extent has been already discussed previously. I make reference to Mr. Bock's presentation. Well, starting with the first problem, that is that of the identification of the notary, we can say that the guidelines, which are really open-ended because they should be able, they should be applicable in all notariats of the Union, and so in principle they are not designed on a very advanced, I would say, technological infrastructure, and so they can be applied.
Excuse me, interpreter's comment. Could you please speak closer to the mic?
An advanced infrastructure. The first problem is that of the identification of the notary, and in any case, if you have or if you don't have an advanced technological infrastructure, the guidelines suggest that the notary should be in charge of the personal and direct identification of the parties that will finally pass the notarial instrument. In that sense, for sure, digital tool, electronic signatures, electronic IDs can be useful in verifying the identity of the parties, but the guidance believe, and we believe in the end in the working group, that these are just complementary tools in the hands of the notary to verify the personal identity of the person that will sign the instrument. So electronic signatures are not a substitute for the notary. Therefore, if this is true, the notary remain the only person that is responsible for identification, for identifying the party, and we think this is a crucial aspect when you have this remote authentication in order to maintain a strong role of the notarial profession. Moving to the second area, to the second part of the guidelines, we can say that the problem of how parties can freely express their will and how the system can be deemed secured are crucial in operating any remote authentication platform. And we believe that these platforms should be to some extent managed or at least controlled by the notariat itself. These platforms shouldn't be in the hand of private persons as a general principle, and the notaries or notarial associations should have the power to approve this platform and to verify that this platform conform with the specification required in each legislation. Obviously, we cannot exclude the possibility that also private platforms are used, but in that case, notaries and national notariats should assess with extreme care, I would say, the contracts with these private companies providing these platforms, and special attention should be given to the use of the data that could be collected through this platform, because obviously we don't want that private companies will use the information that is used for notarial instruments for other purposes, maybe also reselling that data. In any case, the supervision of the security of the platform should be ensured by the notariats, and it shouldn't be allowed to give to private companies the power to, in the end, be the master of the platform. The notariats should be in charge, at least of verifying what is going on in the platform, and eventually also to change the way some feature of the platform is structured. In any case, given that remote authentication may create problems, think for example, if you have problems with the internet connection, or if you don't have enough bandwidth, to have, for example, a video conference, notaries should in any case have the right to refuse to draw up the notarial instrument when they think that all the needed security features have been complied with. And this, in the end, is a decision that should be taken by each notary personally. And so I would say there shouldn't be a right for the parties to pass an instrument online if the notary is not sure that there is a free expression of the will and that the system in itself is secure. Probably the most contentious issue that was discussed in the guideline was that of the territorial competence. As I told you, this is a problem that has two different facets. On the one hand, you have the national internal competence, when you have different regional competencies between national chambers. You may have regional chambers, provincial chambers, and so on, state chambers. And then you have the problem of having a notarial instrument passed in a country that involve parties involved in other countries. Well, for sure, we cannot provide a definitive answer in this guidance to these problems. We just suggest caution. But the final idea that emerged in our discussion was that in the end, what really matters is where the notary is located. So in principle, it should be possible to pass a notarial instrument, so to have a notarial authentication, even if the parties are abroad. The only thing that will be really needed is that the notary is located in the place where he has the authority to pass notarial instrument. So I would say the relevant private international law, the relevant connecting factor, the private international law factor that should be taken into account is that of the location of the notary. But we also understand that this approach can create problems in some jurisdictions. So these jurisdictions should be allowed also to limit the possibility of allowing the signature of a notarial instrument with parties that are abroad. And in some cases, on the other hand, they can also decide that this is exactly what they want. We have some example in that sense in the European Union. So they could reserve this possibility just to citizens, for example, that are abroad, that cannot come in a specific jurisdiction to pass a notarial instrument. A problem that we started considering was also that of the interconnection of the platforms, because all these technological infrastructure are really, to some extent, grounded on specific jurisdictions. Even within the European Union, we have a regulation that tries to harmonize that, but it doesn't really achieve that goal. So something that we should really explore in the future is how we can really connect the different remote authentication system that we may introduce in our legal system. But I think this is something that is more the problem of tomorrow than of today, because all these guidance essentially derive from the need of providing a decent service to our customers during the pandemic crisis. Well, last two slides. The last part of the guidance discusses how you can practically proceed with the signature of the instrument. Since, as I told you, these guidance are, I would say, technologically neutral, we considered both digital and the paper authentication, meaning that maybe you have your video conference and then the notary just prepare a paper instrument. This clearly doesn't require a big digital infrastructure, but for sure it should be possible in some member states that you really have entirely digital instruments. So instruments that are signed with electronic signature, that do not have a paper version, and that then are stored remotely, as it was mentioned also before. Since we are dealing with situations where, again, we may have parties that are in different locations in the world, the guidance also suggests to have the possibility, to recognize the possibility of not having all the parties in the same place at the same moment when you have this remote authentication, so as not to impose on them to be in the same place, even if the notary is away. Something that, for example, in my jurisdiction is possible, but we realized that in many countries was not possible. Notarial instruments had to be passed with all the parties together in the same place at the same moment. Another important aspect, especially if you adopt a strong digital infrastructure, something that was mentioned, if I'm correct, also before, is that notaries may also be allowed to issue electronic signature to clients. And why that? Because if you have a pure digital notarial instrument, the parties will have to sign it digitally, but who can provide to parties these digital signatures? This is a problem that we have now in Italy with the transposition of a directive, and the approach that many member states are going to take is that of allowing notaries to issue this electronic signature to clients in the context of the preparation of the digital authentication of the digital notarial instruments. As I was also telling you before, it is also possible that jurisdictions decide to limit the scope of the notarial instruments that can be passed abroad with this remote procedure. And in particular, emphasis was given to the fact that jurisdictions can consider of allowing that procedure only for power of attorneys, and this will clearly not result in changing too much the role of notaries from what it is today. So to conclude this presentation, this guidance try to maintain the notaries as the key actor, obviously, in the notarial instrument. Digital signatures, electronic signatures, electronic IDs are not a substitute for notary, and they will never be. Maybe there is now the discussion on the artificial intelligence as a substitute for notaries, but I think we are still far from getting there. And the technology in the end remains just a tool, and it can help the notary to pass the notarial instrument, as it helped the pilot in an aircraft to pilot the aircraft in the sky, but it will never substitute the pilot. And on the other hand, if the notary is the key actor, he also remains the responsible person for passing any notarial instrument. This is also important because with all these new technologies, then it is not really clear where liabilities stand. Think, for example, to this artificial intelligence I was mentioning a few seconds ago, and in fact now we have proposals in the European Union trying to address these problems. In the end, what really changed in our guidance is how the personal appearance should be assessed by the notary. And in fact, we recognize that personal appearance can take also other form, electronic form, video conference. In some cases, in some countries, it is also a telephone call that is enough to provide evidence of the personal appearance before the parties. So this is really where I think we should reconsider the role of our national notarial laws and of, I would say, the personal presence before the notary. But in the end, the legal effect of this instrument should remain the same. And in fact, nothing will change in practice from what we are used to do and from what we have been doing for, I would say, centuries now. Thank you very much.
Rahmat, haqiqatan juda ham qiziqarli ma'ruza uchun. Bu kelgusida bularni biz elektron notariat.
Thank you very much. It was a very interesting presentation of yours, and truly we have had very interesting information gathered from you. We would like to pass the floor to our next speaker, and that's the speaker from Germany. And we're discussing these matters of electronic notary service and in particular blockchain technology. So these matters are of a great importance as well. So I would like to pass the floor to Veronika Korman.
Oh, sorry. Excuse me, I was muted. I'm so sorry. Dear Mr. President, thank you very much that I have the floor now. And dear presidents, dear colleagues, ladies and gentlemen, thank you very much for giving me the opportunity to speak here today. And let me quickly share my PowerPoint so that way it would be probably a bit easier for you to follow me. I do very much hope that you can see it properly now. I will talk about a project which is relatively new and in my personal opinion, one of the most interesting projects we have here at the German Federal Chamber of Notaries at the moment. And this is a blockchain-based register for validity of notarial powers of attorneys. Well, the blockchain technology is in the media a lot at the moment. It's very highly discussed. But it's often presented as like the solution to every problem. It's probably not that powerful, but it still can help considerably in everyday life. We decided to use the blockchain for one of our registers, which we are planning at the moment, and which we are trying out at the moment. And you might now probably think, well, blockchain and powers of attorneys, does this work well together? Well, it actually does. But before I go on to present you the blockchain, let me first line out shortly how notarial powers of attorneys work at the moment in Germany. Powers of attorneys come in many different forms. The current system dates back to the 1900, to the German Civil Code from 1900. And back then, they obviously didn't decide for a digital system. The most common thing we use as notaries are lasting powers of attorneys. Lasting powers of attorneys are powers of attorneys where the principal designates a person of their trust to represent them in all personal and financial matters should they lose legal capacity. Let me explain this a bit with an example. We have Mr. K, and Mr. K suddenly has a heart attack. So he is carried to the hospital, and before he even arrives at the hospital, he loses consciousness, so he passes out. there are now a lot of different decisions to be taken very urgently. For example, which treatment should he get? Or then within the next days, who should pay the rent for the flat of the family? Who should continue with his business? All these decisions have to be taken very urgently. It is now good if Mr. Key decides, while he still can, who should decide on these issues. That way, he can prevent a lot of legal uncertainty. If he does not decide on these issues, you have a lot of legal uncertainty. The consequence is that there are a lot of decisions not being taken at all. Some decisions are being taken but not accepted by third people, and deadlines are missed or bills are not paid. By having a lasting power of attorney, you can avoid to have a custodian appointed who usually knows all the details of Mr. Key's life far less than his wife does. The most common form of these lasting powers of attorneys is a notarial authentic act. Oh, this is not correct. Sorry. Well, how do we create a notarial authentic act? The first step is Mr. Key goes to his notary, and the notary speaks to him and discusses what is important to Mr. K, what needs to be in the power of attorney, what does not need to be in there, and he provides him with a personally fitted power of attorney. This power of attorney is then notarized and therefore becomes an authentic act. The original of the authentic act stays with the notary and is archived there. Mr. Key gets an execution copy for his agent, meaning his wife, and this execution copy is then used as the original in the outside world. This original, the execution copy, has public faith. Well, this public faith is really, really important in everyday life, because if you only have the power of attorney itself, you cannot really see whether it's valid at the moment. So what the old system does in Germany is it presumes that the power of attorney is valid as long as you can present this special execution copy. So it doesn't check validity in real life system, because it can't do this, but it presumes validity as long as you can show the execution copy. Of course, sometimes Mr. Key changes his mind and he decides, well, I do not longer want my wife to represent me. I would much rather like my sister to represent me and to decide for me. Well, this is not a problem either, because you can revoke a power of attorney orally. That's pretty easy and pretty fast. The problem is now, as long as the wife has the execution copy, she can still act for Mr. Key. Because of the public faith system, whenever she presents this execution copy, the other side will presume that this power of attorney is valid and act accordingly. Well, most of the time, this is not a problem because the agent will just hand back the execution copy. But every now and then there are problems, and the principal needs to sue the agent to hand back the execution copy. Or if the execution copy gets lost, the principal needs the execution copy to be officially declared void by a court. And this takes rather a long time. Well, the old system worked quite well for about 120 years. But by now, we can do even better. There are several things which can be improved here. Now, in 2021, we can live without a paper document. And we can start to check the validity of powers of attorney in real time, making it unnecessary to have a good faith in an execution copy. We do also not need any presumption rules. And it's also not necessary anymore that the principal claims back the execution copy. Because under the old system, we had the rule that we have an old status quo. The power of attorney was valid when it was erected, and we consider this old status quo to be enforced the whole time until the revocation of the execution copy. With the new system now, we can at any time check the real-time check the validity of the power of attorney. Well, unfortunately, it's not so easy just to convert the power of attorney into PDF. This would be very easy, but unfortunately, it's not very doable because a PDF can be copied as many times as you want, and it would be impossible to get all copies back or to be sure that you get all copies back. Also, the PDF itself cannot show whether it's valid or not. So for the decision of the validity, we still need a register. Whereas for the content of the power of attorney, we can use a PDF. How is this now working out in real life? Well, the first step is the same as it has been before. Mr. Key still goes to his notary where they discuss what should be in the power of attorney and where he gets advice. You then also have a power of attorney that is drawn up and authorized by the notary. The next step, though, is a bit different now, because the notary now scans the power of attorney and converts it into a PDF. This PDF is then uploaded to a register, to a special blockchain register. And afterwards, the notary sends the PDF to the agent, for example, via mail, so that the agent, the wife of Mr. Key, has a copy of the PDF as well. Well, what does the wife of Mr. Key now do if she wants to go to, let's say, the bank and pay for Mr. Key because Mr. Key is in the hospital? Well, all she needs to do now is to take out her smartphone, show the PDF of the power of attorney with all the content of the PDF, and then log into the database and show that this special power of attorney is valid. This can be done really easily and with just a few clicks. So different to before, we do not need any presumption of validity. We can now log in at any time and see or check whether exactly this power of attorney is valid in exactly this point of time. This has a lot of advantages. First of all, you don't need a paper document because paper documents tend to get forgotten or lost, or sometimes they are confused and people bring a wrong document. You also do not need to claim back the execution copy once you revoke your power of attorney, because revocation is now really easy too. All that Mr. Key needs to do is to log into this database and change the status of the power of attorney from valid to invalid. Whenever his wife now goes to the bank and shows the power of attorney and logs into the system will say, this power of attorney is invalid now, you cannot use it anymore. This makes it considerably easier in real life. You may now ask, well, and where's the blockchain technology hiding? Blockchain technology is not so much about how it looks like. It's much more about how data is saved and stored and organized. Blockchain technology is a technology, as the name suggests, where we have a lot of blocks of information and they're all saved in one big chain. Whenever an event occurs, you have a new block. For example, the upload could be a block, or the status of valid could be a block. If you change the status to invalid, you add another block. And as you can see, these blocks are all hashed. This is a kind of an encryption method. And the hash code, which is the thing at the bottom, is then written into the next block. So that way they're all connected. You can only read them in one direction. These blockchains created are not only saved on one server, but on a lot of servers. And they're all identical. So whenever one of these blockchains is manipulated, you will see it because all the others look different to the one that is manipulated. This makes it very, very secure. You may ask, well, why did you not just invent a register and then make a lot of security copies? Well, when we were discussing this idea of the validity register, we found out that there's another stakeholder, the Bavarian State Ministry of Justice, who has a very similar problem with inheritance certificates. Inheritance certificates tell you that the person in the inheritance certificate is the real heir and can take over the inheritance. And they have the same problem because sometimes they're not correct and they need to be withdrawn, and you need to use them to, for example, access bank accounts. So now we have different stakeholders. And what blockchains can actually do is that you have a system where different stakeholders all have the same level of power. They all have the same way of accessing data. Nobody has to completely hand over its power to the other one. There's not one entity having all power over all data and the whole register. And because it is saved on several independent servers, everybody can check whether it was manipulated at any time. You may ask, well, and data security? If you have so many copies, how will you ensure this? This is not a problem for blockchain technology either. Our blockchain is protected in different ways. First of all, the users do not see the whole blockchain. They only see the user interface showing you this is valid, this is not valid. And furthermore, we do not upload the POA, like the power of attorney itself, into the blockchain. But we hash the blockchain. This is a special encryption method, and then upload the encrypted version of the power of attorney into the blockchain. And this encryption only works one way. If you have the hashed version on the blockchain, even if you get it for some reason, it is impossible to convert it back into the power of attorney. But if you have the power of attorney, you can still check whether it's the same one as the one saved on the blockchain. And furthermore, the blockchain enables us to have different rights granted to different people. For example, the notary needs to be able to upload the power of attorney. The principal needs to be able to change the status of the power of attorney from valid to invalid or back to valid. And other people only need the possibility to check the validity. They only need to log in and see, valid, what is the status? And furthermore, and this is also very interesting, it is always possible to add new authorities and new documents. So with this blockchain, we could later possibly also include driving licenses, for example, or other kinds of contracts to be saved. While you may now ask, if you have this super modern blockchain technology, are notaries useless now? Well, not at all, because computers can probably decide on the very easy issue if something is valid or not, if you change the status in a database. But what computers cannot do is to figure out what kind of POA is actually needed. They cannot figure out what are the problems in Mr. Key's life, what things do need to be regulated, who should represent him. Computers cannot give legal advice. So that's what we need notaries for, still now. Notaries provide the legal advice to Mr. Key and all the other civils. They determine the needs of the clients. And because they have legal skills and very smart mind and a lot of experience, they can actually draw up the perfect power of attorney for each individual. The only thing computers will do, and this is also very important, is that they can now show in real time whether powers of attorneys are valid or not. And this is what we should dearly use them for. So at the moment, our archive, or like our blockchain technology, is still in a tryout phase, and we're going to elaborate on it further. But we have great hopes in this technology, and we're eager to see how it develops. Thank you very much for listening to me.
Rahmat katta, Meranika xonim, haqiqatan shunday qiziqarli ma'ruzalar bo'lyaptiki, bizda vaqtimiz ham yetmay qolyapti.
Thank you very much, Ms. Veronica. And that was very interesting and very important to us as well. And now the floor is given to Antoine Dejoie, representative of the High Council of the Notaries of France, Central Asia, and he participated in the previous forum. And the topic of his presentation is
You can hear me?
the
Monsieur le ministre, Monsieur le président de la Chambre des notaires de l'Ouzbékistan,
yes.
Mesdames et Messieurs les représentants des notariats présents à ce forum. Je suis heureux d'intervenir pour la première fois au nom du notariat français dans le cadre d'un forum à Tashkent en Ouzbékistan. Je vais donc évoquer les problématiques électroniques à distance et la comparution à distance. L'avènement du numérique représente une véritable révolution en matière de droit, dans les habitudes de travail, la productivité et le rapport au travail. Le notariat français a entamé, au tournant des années 2000, une révolution assumée et stratégique, la dématérialisation de son système d'information. L'acte authentique lui-même est devenu électronique. Aujourd'hui en France, 90% des actes authentiques sont reçus sous forme électronique. Et plus de 1 500 000 actes sont archivés chaque année par les notaires français. Ces actes n'ont plus une existence papier, mais uniquement une existence informatique.
Какой канал? Я говорю, реле. Нету русского. So now they will exist not on paper but electronically. And if I discuss it in greater detail, so paper-based documents confirm the validity of any given matter, and actually we also need to verify the equivalence of the electronic version, and the signature is also put electronically on the platform, and then one has to verify the signature by pressing a button on the platform, and actually this was initiated last December by a decision of the government number 597, and so now it has been formalized, the whole process. After the document is signed electronically, automatically it is saved in the archive, and notaries have access to that archive, and it is stored for 75 years. The main restriction in the electronic platform is related to archiving, because you need to make sure that this is the original and then you need to sign it, and it takes time. To verify, to check the original. Such restrictions could be managed by the notary, and that system is used by the notary. The interpreter into Russian is saying there is no sound. The English booth apologizes because we are taking the sound from them. After signature is put, then the document is archived and placed in the central archive. And we are developing this system further now. And as compared to electronic documents, these documents are not meant for storage, so you can use them just to understand that better. And so the postal address has been updated 3 times. So internet connection, the broadband is provided, and so the file, the document is stored, and in case you need, you can verify that this is the real equivalent document, and the institutions making use of the platform should make sure that the document is authentic. And the technology matches all legal standards. In addition, information systems need to be adapted to that. Again, there is no sound, the Russian booth is saying.
À ce jour, absolument adapté à l'acte authentique sur support électronique. Des adaptations constantes sont donc nécessaires.
Currently, electronic means available so far. Very few. I mean, the ones matching the requirements of the platform, and we have to constantly adapt them to our requirements. And that system safeguards document storage. And well, for more than 20 years, we've been using our system, but the problem is to ensure longer term storage and safety of documents, especially security of academic and military documents or others. And next, to be able to read documents in the central archive. So we use HTML and there is one more possible format for file storage, which is namely the PDF. And such documents also could be stored in facsimile format. And such formats could be used on various devices. First of all, I would like to speak about distance operation. So this document makes it possible, that system makes it possible to use the document at the same time for many institutions, and it also enables a notary to operate. And the new opportunities are as imply safe video conferencing with clients and all procedures are carried out over a distance, which makes it possible to save time. So that system has been in place in the last 3 to 4 years due to COVID-19 pandemic. That system development was accelerated and the client doesn't have to be physically present at the notary's office. So video conference is used instead. The next point I would like to raise is about the video conferences, where first the client should confirm the identity, and if the notary knows the person, maybe previously dealt with that person, maybe signed some contracts, in that case they switch to electronic signature. In other cases, measures shall be taken to verify the identity, because the notary has to confirm the client's identity to be able to work with them. During the first wave of COVID-19, such platforms made it possible to put an electronic signature, but after August 2020, following the governmental resolution, now the opportunity is granted for registration. And to sum up, I would like to say that the electronic system is one of the services which is broadly used by the state, and it makes an effective contribution to the state's development.
It gives great opportunity to review submissions and saves time, and also reduces paper use. And it also provides for the work of postal mail offices as well. So this system is a lot better for the state and economic-wise. So without comparing to processing all other elements. So French notariate at the remote basis, they are performing notary actions and all the processes, and it's being supported by simplified mechanisms. Thank you very much for your kind attention. Thank you so very much, Mr. Dejoie, for your presentation. We have become the observance, and we were able to witness of so many interesting approaches. So practically, we may not limit the activity. So we were able to see that everyone in their life span have several times addressed your notary services. So that's the part of our life. Unfortunately, we do not have time for questions and answers session, and we will continue our questions and answers when we will see each other in real time. But using this great opportunity, I would like to say that all our colleagues who participate during this activity, during this event, also Mr. Richard Brock and Mrs. Christina Arnella, we would like to express our deepest gratitude on behalf of the Ministry for Justice and also on behalf of the Chamber of Notary Services of the Republic of Uzbekistan for the great support from the International Association of Chambers of Notary Services. Thank you very much, and I truly hope that during other following up forums, we will not apply Zoom platform, but it will be done in the real life. Once again, thank you so very much, and all the success in your endeavors. Thank you.
Thank you very much.
Thank you so much.
Thank you. Goodbye.
Thank you. Bye-bye. It was a very good performance. Thank you.
Дякую всім за увагу. Гарного дня і здоров'я.
Thank you. It's great to be here with you guys today and to meet you virtually.
Уважаемые коллеги, я думаю, уже пора начинать.
At least virtually, as Ambassador said, but hopefully next year we will be able to meet in person. My name is Maria Slazak. I introduced myself, but I was muted, and I am from Poland. Very nice to meet all of you.
Nice to meet you.
Good meeting you.
Welcome, Maria.
Yes, thank you.
Hello, Maria.
Oh, I see Lydia and Anna also. Hello, friends.
Nice to meet
Hello. Some of us, we know each other.
Yes.
Most of you are in the offices. I work, and in my country, we work remotely, mainly that I'm at home. But Anna with beautiful flags.
A lot of us are still working remotely here as well.
Yes.
I have not been back to the office yet.
Yes, most safe, most safe. Somebody said that we will start shortly.
Co-moderator Davron is speaking.
Всех участников Второго международного юридического форума Палата адвокатов Республики Узбекистан вместе с Министерством юстиции организовал этот круглый стол на тему перспективы развития адвокатуры в условиях реформ судебно-правовой системы для того, чтобы обсудить ряд вопросов.
In order to discuss a number of matters which are now part of our agenda, and also to discuss those changes and reforms which happened in the Republic of Uzbekistan from the moment of our first law spring. And in the year 2020, there were revolutionary regulations and bylaws has been adopted that foresee the establishment of the defense attorneyship system in the Republic of Uzbekistan to meet international requirements, to strengthen institutional good grounds for the bar status, and also to increase the role of attorneys in protecting rights and liberties of physical and of persons and legal entities. I'd like to pass the floor to the Deputy Chair of the Chamber of Advocates, to Mr. Sadikov. But I would also like to say a couple of words about the rules of engagement. I kindly ask everyone to turn off your cell phones. Should you have any questions, you may prepare them and they will be discussed in the end of our roundtable. So the floor goes to Shuhrat Sadikovich.
Assalomu alaykum, xonimlar va janoblar, aziz mehmonlar, bugungi Navro'z suhbatimizning ishtirokchilari.
Dear participants of today's meeting, if you allow me, I'd like to congratulate you with the forum that we're having today. And I'm so very much thankful to all of you for being here with us on the behalf of the Chamber of Advocates of the Republic of Uzbekistan. I truly hope that today's roundtable will be very much useful for all of us, and it will be a good platform for collaboration and discussion. You know that within the whole year of pandemic, and it's still ongoing, we know that those incidents that happened and those events that happened during this period of time, once again, we are quite sure that everything that's going on right now shows that we have to continue the work that we do. We have to utilize all this novelty. We have to become new. We have to develop our mindset in a new way. We have to approach completely differently to the work that we do. 2 years ago, I may say that if we were having any type of activity or any type of event, we would discuss different matters. Right now there are so many reforms ongoing in the Republic of Uzbekistan, and I truly hope that our today's meeting will be of a great interest for all of us. Based on the discussions of today, we will be able to find good ways of resolving those challenges that we have, and we will enrich our knowledge. This is my hope of today, and I truly hope that this discussion will be of a great interest for everyone. Thank you. I'm passing the floor to Mr. James Eaglin, my co-moderator, please. Regional Dialogue, James Eaglin, please.
Thank you very much, Ambassador Rosenblum, First Deputy Chairman of the Chamber of Advocates, distinguished presenters, and dear participants. As my good friend Davron said, I'm Jim Eaglin. I'm with Regional Dialogue. And on behalf of Regional Dialogue, we are very pleased to have worked with the Chamber of Advocates to put together this particular roundtable, to organize this important roundtable on the prospects for the development of the legal profession in the context of judicial and legal system reforms. Now, this roundtable is especially important in light of, as Davron said, recent positive legal advancements impacting lawyers that have already been made in Uzbekistan. But this roundtable should also serve as an important reminder that more advancements are clearly needed. There should be some urgency to finalize consideration of the working group's recommendation on the draft concept of the law on advocacy, and then the law on advocacy should be enacted. Another relevant consideration that serves to confirm the importance of this particular roundtable is the stark reality that today in Uzbekistan, there is only one lawyer for every 8,660 citizens. So unless the number of new lawyers coming into the profession is increased, the overall future prospects for the legal profession in the country will be directly impacted. We are very honored and we're excited to have with us today our United States Ambassador, the Honorable Daniel Rosenblum. Ambassador Rosenblum has served in that position since May of 2019 and has served in a number of other important positions within the United States State Department, much of it with a focus on Europe, Eurasia, and Central Asia. Mr. Ambassador, thank you so much for taking time from your very demanding schedule to be with us today. Your presence here is a testament to the important role of legal advocates in a democratic society like Uzbekistan. Mr. Ambassador, the podium is yours.
Thank you very much. Assalamu alaikum to everyone. Hello. And good morning to my colleagues who are in the United States. I want to thank you for inviting me to participate in today's panel to talk about reforms of the legal system, judiciary in Uzbekistan. As everyone here knows, Uzbekistan is undertaking fundamental reforms of its entire state and system, touching on literally every aspect of governance. And all of these reforms are important. But in my view, nothing is more important than the reforms of the judicial branch and the legal system. And for that reason, I'm so glad to be participating today. In any political system, it's the activities of the executive and the legislative branches that tend to get the headlines and be watched more closely. But looking back on our own history in America, I'm convinced that we owe our long tradition, our long unbroken tradition of democratic government and our history of economic growth, most of all, or at least equally, to our judicial branch, our Supreme Court and other courts, and our legal system. That judicial branch has stepped in time and again in our history to rein in executive authority when it was overreaching, to protect minorities and minority interests against unjust state action, and when needed, to protect individual property rights. So in a very real sense, the issues that you are gathered here to discuss today will determine the long-term success of President Mirziyoyev's vision for a modern, thriving Uzbekistan. Now, at the heart of judicial reforms is creating a state with a strong rule of law. Without rule of law, reforms ranging from human rights to economic issues can't succeed. And in particular, it's worth noting that international businesses, or at least the type of international businesses that we want to have here in Uzbekistan, won't invest unless there are guarantees that their investments are secured by a strong rule of law. So the development of the legal sector is paramount to this effort. The United States, our embassy, and the State Department are proud partners of Uzbekistan through our support for many different programs in this area. This has included trainings, judicial partnerships, law school partnerships, exchanges, workshops for students, for judges, for advocates, with coming to the United States, and also partnerships that we've facilitated with other international experts, non-American experts, and specific programs that we've done with the Chamber of Advocates to strengthen their professional growth and their independence. We've had excellent cooperation over many years now with Regional Dialogue, and I want to thank Regional Dialogue specifically for all its wonderful work in this area. And Regional Dialogue has played a key role in the development of the Chamber of Advocates, and also working closely with Tashkent State University of Law to ensure that ongoing programs in legal education are of the highest quality, together with U.S. law schools and U.S. legal experts. As has been noted, the event today is happening at a time when the government of Uzbekistan is in the process of revising the law on advocacy with the intention of strengthening the independence of the Chamber of Advocates and better supporting the role that advocates play in Uzbekistan's judicial system. We strongly, strongly support this reform and this revision of the law. Advocates are typically the underdogs of any justice system, often lacking the resources and influence of prosecutors and judges. But ensuring that advocates have the necessary tools to represent their clients is an essential step in the long and difficult journey of building a fair and just society in which the rights of all citizens are protected. The first and most important role of an advocate is to defend the rights of their clients from unfair practices and to seek impartial justice in a court of law. This can be very difficult to accomplish when defense attorneys experience undue influence or lack the support of an independent Chamber of Advocates. Equally important are advocates' role in fighting corruption and ensuring the balance of power between the different branches of government. A word of caution, of course, is in order. The formal guarantees of independence for advocates are necessary, but insufficient for actual independence to exist in practice. These laws need to be implemented and enforced. Building such a system will not be easy or quick, but it's absolutely essential. So in closing, and to allow the discussion to begin, I just want to say how glad I am to see representatives of some of our own bar associations from our own states, Ms. Teskey and Mr. Bond, who are here from Minnesota and Massachusetts here today. I'm sure their insights will be very valuable for our discussion, and I look forward to hearing what everyone has to say. Thank you again. Katar Rahmat, spasibo большое. Thank you.
Thank you very much, Ambassador Rosenblum, for your very important and timely comments. Regional Dialogue and all of our partners in Uzbekistan continue to look forward to your strong leadership in supporting democratic reforms, not only in Uzbekistan, but in the region. So thank you again very much for being with us. I will now turn the podium over to my friend Davron to introduce our next speaker. Davron.
Спасибо, Джеймс. Я с удовольствием хотел бы
Thank you very much, James. It is my pleasure to introduce our first speaker, our colleague, the partner of the law firm My Lawyer, member of the Chamber of Advocates, and he was one of the lawyers who was developing the concept for lawyers in the Republic of Uzbekistan. So he is the best to tell us about our national prosecution, how they see, I'm sorry, not the prosecution, I'm sorry, defense attorneyship, and how the advocates of the Republic of Uzbekistan envision us in future. Его плохо слышно.
Добрый день, уважаемые участники. Ассаламу алейкум, еврейских катнашчылары. Я очень рад всех приветствовать. Для нас большая...
Good afternoon, distinguished participants. It is our great pleasure to participate in this roundtable, which is devoted to a very interesting topic with regard to defense attorneys and lawyers in general. So before we see my slides on the screen, I'd like to tell you the following. Next slide, please. I would like to bring your attention to the following of our participants, to the words of very famous thinker As-Samarkandi Muhammad Zahiri. So he mentioned once, the good ground for every state and the fundament of any country are based on the fairness and justice. And the words of another ancient scholar Avreli Augustin. So if you do not have fairness, there is no justice. So in reality, our lawyers, from the moment of establishment in 1975, the first advocacy that has been established in the territory of the Republic of Uzbekistan, it has been established by the graduate of St. Petersburg University in 19th century. So, and that was the office of protectors or of defendants, of defense attorneys. So, and we were able to undertake quite an important and difficult pathway to develop our work. So, and His Excellency, Mr. Ambassador, has mentioned that if there is rule of law, only then human rights will be obeyed. And in the country where we have strong courts, strong judiciary, we will see the interest of international investors, and further development of the country will be obvious. So, starting from 2019, we switched to a complete new next stage of further development of the system of justice and judiciary. So, and of course, the reforms were ongoing also for the advocates. Well, starting from 2012 until 2016, one of the indicators of development that we may bring to your attention, in our country, we only had 7 acquittals. So, and starting from 2017 until 2020, the number of acquittals has grown up to 2,000. So that was great jump, truly, that has been done based on the work of our defense lawyers, who within a lot of time, they keep working in protecting, in defending the human rights and liberties in our country. Before I start the discussion of this concept, I would like to emphasize very important number of legislative acts and regulations that pushed truly the development of defense attorneyship in country. So you see the decree of the President of the Republic of Uzbekistan dated 2018, the number of which is 5441, on the measures to improve the efficiency of defense attorneyship and expanding independency of lawyers and advocates. Well, that was a fundamental regulatory base that became an impetus to further develop defense attorneyship. For the first time, openly, the president of our country was able to bravely state those problems and challenges which we are facing here. So all the problems has been discussed. There is that the status of defense lawyers should be strengthened, and that we have to provide for full independence and full participation, and to provide for equality of arms, to protect the interest of and human rights of all the citizens. In that decree, we also have a very important and very serious provision item that tells us that any changes, any amendments to regulatory acts which rule the activity of defense lawyers have to be agreed upon with the Chamber of Advocates. So that document has become a strong initiative for us to come up at the different stage, and within 30 years of our existence, for the first time, we were given great opportunity to be active participants in developing the whole concept for further development of defense attorneyship of all advocates in our country. So next decree or resolution of the president based on the previous decree. So now we have number 4551 to provide for the rule of constitution, to strengthen the public and civic control in that regard, and also to improve legal awareness among the population. It is foreseeing the adoption of the whole concept for further development of advocacy institution or defense attorneyship or the bar work in the Republic of Uzbekistan. So besides, again, our president has approved this concept. And another very important item here, that within 30 years, the development of current concept has given us great opportunity to, for the Bar Association, for the Chamber of Advocates of the Republic of Uzbekistan to be fully involved in this work. Like before, development and drafting of this type of documents has never been done by the chamber. So based on this resolution, so under the Bar Association, the Chamber of Advocates, we've established a working group to develop the concept, to further develop bar institutionalization or defense attorneyship institutionalization in the Republic of Uzbekistan. Another very important document has been adopted, and that based on the law on regulations of the Republic of Uzbekistan. This document has quite strong legal force. That's the joint decree of King Ashes of both chambers of 2019, and in the item in the paragraph 5, there is also in the item 45, I'm sorry, there is a roadmap approved, so that there will be a law on bar activities, or the law on advocates. So the whole society of lawyers, we welcomed that with quite a high level of aspiration. So all the work that is being done right now by working group, we have them here with us. They participate in our roundtable. We have representatives of working group, which has been approved by the resolution of our chair. I'd like to express my deepest gratitude to each and every of you for the hard work that you've introduced, that you've contributed to develop this concept.
And we will discuss the challenges we are facing today. In addition to that, next slide, please. All the issues faced by the bar. Well, we tried to make the draft concept available in the public domain, so it's available to the public as much as possible, and we received a lot of suggestions from our community of Defense Council, and actually the bar should decide on further development of the attorneyship because it's an integral part of the legal system in our country, and all the feedback, all the comments received from the bar were actually included when we finalized the concept jointly with our colleagues from the Ministry of Justice of the Republic of Uzbekistan. And on top of that, I would like to extend special gratitude to our partners, namely international organizations, USAID, Regional Dialogue, UNODC, OSCE, the Federal Chamber of Germany, chambers from other countries for their great contribution they made, thanks to their experts, to improve and refine the concept initially developed by the working group of the Chamber of Advocates. So the measures and steps suggested in the concept, first of all, aim to establish the legal and regulatory framework, the basis, to change the attitude towards the advocates in the society. So everyone could realize the most important role played by the advocates to uphold the rule of law and to protect human rights. And when we were on the concept, actually the primary objective was to shape the independent, professional, effective bar without which any legal and regulatory reforms are impossible in any country, in Uzbekistan as well. So institutional independence of the bar receives special attention, as well as enhancing the status of the attorneys and that there are relevant opportunities and relevant environment for the bar to operate. Next slide, please. I would like to discuss the main provisions of the concept. So initially, the concept our working group has developed envisaged a number of measures which the bar believes are aimed at real development of the bar. And I would like to highlight the following of them. In the context of my today's message, of course, I won't be able to highlight all the items, but I would like to highlight at least some of them. So, free establishment of the bodies under the Chamber of Advocates without any external interference by advocates themselves, then nomination to become a chair of the Chamber of Advocates based on the results of the voting, and then to develop the mechanism for self-governance for the bar, so we could meet the principles of independence, autonomy, and a number of provisions which were enshrined in the draft concept. So the Chamber of Advocates should be given exclusive competencies and powers on issues related to access to that profession, and we need to highlight that. In fact, when we started the fourth stage of judicial and legal reforms in 2016, we are feeling the changes and the attitude of the state towards the bar, because in fact, it's a sign of the attitude not to the advocates themselves, but finally to the citizens, to their status. So the extent to which the advocates' rights are protected is the extent to which the citizens' rights are protected in the country where an advocate works. And that's why this concept envisaged establishment of the four-tier structure for the governance of the Chamber of Advocates. So we have the supreme body, executive bodies at the Republican and provincial levels, and also the qualification commission. And we also need to grant the advocates the rights to ensure long-term evocation of the persons managing the Chamber of Advocates, because we believe that there should be the disciplinary committee and the qualification committee, but we now have only the qualification committee, and in line with the international standards, of course, the powers of these two commissions should be separate. And the fourth step of our judicial and legal reforms in the country also suggests that our legislation would become consistent with the international legislation. And in all his messages, our president has correctly mentioned that definitely the objective of any given reform is to ensure protection of rights and interests of a person. So the reform is not done for the sake of reform. So it shouldn't be just formal on paper. No, it should be done to ensure a real mechanism to protect the rights of people living in our country. And as it was correctly mentioned before me, and distinguished Mr. Ambassador and Mr. Iglin, they all said that we need to ensure our judicial system is fair, and the bar is an integral part of that system. So the second point is that we actually were considering abolishment of licensing of that activity so that the Chamber of Advocates could deal with those issues on its own. Then the activities of the disciplinary committee, we've mentioned that before. And next slide, please. Next, we need to cancel the requirement of having a 2-year work experience for those willing to become advocates, but 3 months mandatory period of internship should be kept for all nominees, for all those willing to join the bar. And in the beginning of my message, I also mentioned that the bar has undergone a very challenging path, and in 2008 there was an attempt at reforming the bar to make it better, but the community of advocates do know that there were a lot of deviations, and as a result the reforms planned in 2008 were not implemented. And in 2008, in that very year, the changes were introduced to the law on the bar, and the 2-year mandatory work experience was introduced for those wishing to become an advocate. And in fact, that represented the barrier to young people, those willing to become an advocate, and that was a big problem for us. And currently the number of young advocates under 30 is very low, and their number is going down. If we compare it to indicators, as of 2009, so the tentative number of advocates was some 4,000, like today. So the number of young advocates under 30 accounted for more than 230 persons. Now it's less than 50. So it's catastrophe. And actually, our colleagues from the Ministry of Justice also paid attention to that rate. And we do know that our colleagues from the Ministry of Justice pay much attention to make sure that our young people are interested in that most interesting profession of an advocate. The next important step, which we also outlined in our concept, is improvement of the advanced training program for advocates. Now we have the Advanced Training Center, Professional Development Center, but having analyzed the experience, and since we had to harmonize our legislation, including the main principles related to the role of the advocate as approved by the UN Congress in 1990. So we plan to establish the independent professional development system by the Chamber of Advocates. So we pay special attention to that, and also introduction of the system for accreditation under the Chamber of Advocates, and as well as training centers and training institutions where the advocates can upgrade themselves. And the next is enhancing the safeguards for rights and also procedural status of an advocate. And definitely, without enhancing the procedural rights of an advocate under criminal proceedings, without ensuring compliance with the adversary principles, when advocates have equal powers to present evidence, without that, so real adversary proceedings are not possible. And without that, all reforms of the bar, in fact, will produce only the minimum effect. And it will not be a full-fledged reform, and that's why it is essential that today this state and so the leadership of the state pay adequate attention. Our president has repeatedly mentioned, and also that's reflected in the legal and regulatory documents we have mentioned before in this beginning of my presentation, that's the presidential resolution as of 2018, 2019. So they all mention the need to enhance rights and status of advocates, refinement of the legislation on the bar, and harmonizing it in line with the international standards. So finally, I would like to say that only given the strong and independent bar, we can carry out effective judicial and legal reforms. And that's why the soonest approval and translation into practice of that concept, and also formalizing its provisions in the new law on the bar and activities of advocates, including and also in procedural codes, will become important for further effective development of the bar in Uzbekistan. The next slide shows you the references, the links where you can find the drafts developed by the working group. And I would like to mention anyway, these drafts were finalized also by our colleagues from the Ministry of Justice, given the legislative techniques. And since our concept was ready back in March 2020, many provisions of that concept were already implemented into the effective legislation. And we do know that now the law is being developed on courts, the new revision of that law, and the limitations in the current law on courts, namely Article 61 of that law, saying that a person can become a judge, and the priority actually is given to staff of law enforcement agencies. And now, thanks to efforts of our colleagues from state authorities, these provisions, as we are aware, are now becoming harmonized. And now the advocates also enjoy the same right, the full right to become judges when they reach the age of 35, like the same right is given to all other representatives of the legal system. So I hope I am within my time limit, and if anyone has questions, I'm willing to answer. Thank you so very much for such an informative presentation, for such a message. Jamshid Turdaliyev made a very important personal contribution to the activities of the working group, and we can say that his motto was that let's in expression, or either I will find the path or I will make the path myself. So we also sent the draft concept to colleagues in other countries, and we received very good feedback. So I would like to give the floor to my co-moderator, Mr. James Eglin, so he could give the floor to our next speaker.
Thank you very much, Davron. And I think Jamshid has put us in a very good position to understand the status of every reform that has taken place in recent months and years in Uzbekistan. At this time, I'm pleased to turn the podium over to Ms. Amanda Pinto. Ms. Pinto is chair of the Bar of England and Wales. Ms. Pinto, it is so great of you to take time to join us. The podium is yours. Thank you.
Well, thank you so much for inviting me to speak at this conference. It's an honor to be here and to give an English perspective on the importance of excellence in advocacy. When I think about the power of advocacy in the UK and how it has evolved, I think first of the features that underpin the way justice is delivered in England and Wales. We come from an oral common law tradition, and those two traditions underpin other aspects of justice in our country and inform how our profession and its excellence in advocacy has shaped our reputation as a jurisdiction of choice for litigants around the world. And if I may, I'll start with the common law tradition. In England and Wales, central to it is the fact that the interpretation of the law that Parliament has passed has always been left to the courts. And this has led to a living and adaptable approach to legislation by the judiciary, looking to dispense justice in accordance with legislation, but also with equity and common sense in a modern context. On the other hand, where every eventuality is catered for in a civil code, the ability of the court, or indeed the requirement of the court, to take a flexible interpretive approach to the application of the law to the facts of a case as time goes by is reduced. And turning to the impact of an oral tradition, where courts are bound by precedents, the earlier decisions of higher courts, the impact of advocacy becomes central to the results, particularly where advocates have a professional duty to ensure the court is aware of any legal decision, whether it helps their cause or undermines it. And that leads me on to open justice. One of the positives of an oral tradition is open justice and transparency. If decisions are made only by the judge on the papers and evidence is written down but never tested, the public cannot understand, let alone see, what has been at work in deciding the case. Equally, the amount of effort and the language used, for example, in witness statements which have been honed and prepared for court by lawyers, might well produce a different result if there is no opportunity to challenge the witness and cross-examine them face-to-face or, in these times, remotely. But where contentious evidence is oral and submissions are made out loud, it has two effects, both a particular one and a general one. Specifically, someone listening or reporting proceedings can evaluate the witness and the submissions for themselves. Where the judgment is delivered in open court, that too makes it not just available, but encourages transparency and sound reasoning. And open justice encourages and is helped by excellent advocacy and excellent advocates. That's where the power of advocacy comes in my view. Barristers have a duty to the court. We are officers of the court and we owe a duty to the court. Misleading the court is a disciplinary offence for a barrister. But putting aside the interest of the advocate, it makes for good law and good decisions in individual cases. If the court has all the case decisions it should consider before delivering a judgment, it will be in a better position than a court that has advocates with one hand hiding case law that doesn't help their cause, but may objectively assist the court to determine the case properly and may even be binding on it. And we have numerous examples of where that interconnect can make very big differences to results. Those aspects underpin the crucial part that excellent advocacy plays in our country. And that's why I believe we have such a strong history of powerful advocates and why barristers are continually training and considering better ways to do their job in the interests of their client, but also more generally in the interests of justice, and therefore more generally in the interests of society. So that is the framework. What are the other assets that barristers have to make advocacy in England and Wales so strong and attractive? Most barristers are self-employed. About 20% of barristers are employed, for example, by companies or indeed in law firms. But most barristers who are sole practitioners, self-employed, typically work from chambers, which are groups of barristers sharing services and their administration with other barristers, increasingly in specialised areas of practice. Domestically, within the UK, we are required to follow what's known as the cab rank rule, like hailing a taxi, which means that we must take a case, whether we like the client or the argument or not, as long as we are available, it is in our area of expertise, and there is a reasonable fee. This leads to far greater justice for all. However unsympathetic a client's case is, they will always be able to get expert representation because of the cab rank rule. But it's also good for standards of advocacy. Perhaps the most obvious way in which this can be practically demonstrated is in my own situation. Within the last few weeks, I have prosecuted for the Serious Fraud Office. I have defended against the Crown Prosecution Service in a corruption case, and I have sat as a judge in a series of serious criminal cases. So I'm able to prosecute, defend, and I know it's unusual, also able to sit as a part-time judge. I'm available to represent clients in my area of practice, and because all judges in the UK must have been lawyers first, I'm also a part-time judge. Because of the independence of the judiciary and the independence of all lawyers, whether employed or self-employed, that is not only a possibility, but a reality. I just want to touch, if I may, on a number of specific areas that I think has made a very big difference to the quality of advocacy in the UK. First of all, collegiality. We all must belong to one of 4 Inns of Court. They are a bit like colleges. They are Gray's Inn, Lincoln's Inn, Inner Temple, and Middle Temple, which is my inn. And they are tasked with providing continuing education, but also friendship, shared legal experience, and help for all barristers, as well as housing a very large proportion of the profession in chambers within their grounds. I don't know if any of you have been to London, but you will know if you have, that there is a part of London which is genuinely legal London. It's beautiful and it's amazing. You come straight off Fleet Street into a different world. And if you ever come, please let me know so that I can show you round. These inns and those factors promote better knowledge and shared experiences of how best to approach cases and how to present them. In the light of COVID-19 and the greater use of technology and remote hearings, all shared experience adds to better advocacy in new operational norms. The inns train barristers in ethics as well as legal education, such as advocacy skills. And they also cross the divide between the bench, the judiciary, and the bar, the lawyers who appear before them. Because whether you are a barrister or you were a barrister and you become a judge, you remain a member of your inn. Because the judiciary here is not a career profession, but one you can only join after years as a solicitor, barrister, or legal executive, the judiciary understands what it's like to be in the pressured position of an advocate. And that makes an advocate's job easier and, if not done well, harder. But it's more accountable. Ethics training. Our code of conduct is taught and courses are given by the Inns of Court throughout practice. I am an ethics trainer for Middle Temple as well as an advocacy trainer. We teach the code of conduct to barristers before they start practice, and we discuss ethical problems that arise, not just at the beginning, but all the way through practice. The Bar Council's ethics helpline has been very widely used. There are usually about 6,000 calls per year, in addition to all of the other help that's available. And ethical problems have increased in the pandemic. For example, with many barristers concerned about their own position when ordered to go to court in person, if they are shielding, for example, or whether it's appropriate that a client attends a case remotely when everybody else is in person, or whether a client will be able to understand proceedings if they are literally using their phone in order to zoom in. May I just mention QCs? I am what's known as a Queen's Counsel. That's an internationally recognized mark of excellence in advocacy, which is about 10% of our profession. But the important thing is that both this competition and the appointment of judges is done by transparent and independent commissions. These are vital, I believe, to the authority and attraction of London as a dispute resolution centre of choice. And it's worth remembering that the number of commercial cases in London has more than doubled since 2015, and the number of barristers serving foreign clients has doubled in a decade too. London is attractive because of the rule of law, which the Slin Foundation, of which I'm proud to be a trustee, enhances internationally. And it's made up very much of English judges, many retired, but some still in practice. Because English judges don't take bribes, are not seen as favouring one litigant over another, and in particular in an international context, not a home litigant over a foreign litigant, and don't generally get lent upon by politicians, there is obviously a great attraction. And one of the other things is that in the UK, we are often specialists, which means judgments are better reasoned, outcomes are more deeply understood than elsewhere, and the common law has been able to adapt to new kinds of business dispute. And it's great at looking forward to appropriate areas of commercial operations and large cases. I could not end without mentioning our efforts at ensuring diversity of those who are lawyers and who progress throughout their career to the highest echelons. Our profession must be representative of society. It must be diverse and inclusive as a profession. That is the way that we better represent members of the public. And we are making serious efforts to become more inclusive. That will add to our ability to allow better access to justice for all citizens. And that is a route that we need to keep on steadfastly, not just for the betterment of our profession or the betterment of justice, but better to enable justice for all. We welcome all efforts from which we can learn from our overseas colleagues and those in other professions. COVID-19 has brought many hardships and difficulties for society to the fore. But if I may bring one positive out, it has also demonstrated the great friendship and the huge support that lawyers around the world have given to each other for the benefit of our professions, better to learn from each other, and for the benefit of our justice systems. And my hope and expectation is that that collaboration and help will continue long after the pandemic has become a distant memory. Thank you very much.
Thank you very much, Ms. Pinto, for your very unique perspective on the English experience, and especially for sharing with us the concept of open justice and your unique experience both as defender, prosecutor, and a judge. That is indeed very unique. So thank you very much. At this time, I will turn the podium over to Davron to introduce our next guest. Davron.
Спасибо, James.
Thank you, James. It is my great pleasure to introduce our next speaker, a president of the Federal Chamber of Lawyers of Russian Federation, Yuri Sergeyevich Pilipenko. Well, if I will start naming all the titles of Mr. Yuri Sergeyevich, then half of our time will be covered by just to cover that, to introduce him fully. He devoted more than half of his life to the legal profession. So the topic of his presentation is the fate of advocate or defense lawyer. Good afternoon, distinguished participants, my friends, my colleagues. Thank you so very much for introducing me so well and kindly with your kind words. You probably see that the topic of my presentation is quite epic, I would say, dramatic. So the destiny actually of a defense lawyer. So, and it will be epic actually, but I don't want to dwell on the construction of Russian advocate work, but still it is very much interesting, of course, and it deserves to be explained to you. So, but I have this first impression of today. It is very joyful for me to remember the forum of 2 years ago when we gathered in Tashkent, and it was quite obvious all those efforts that are being put by the Ministry of Justice and all the organizers of that forum that has been undertook for all the guests and all the delegates and participants to feel at home. So we keep remembering that. But of course, I feel sadness. It is my regret that we are all, due to the efforts of that in-fashion disease, we do not have great opportunity to see each other in this beautiful city of Tashkent, to exchange our views, to share our ideas. But I have a hope that our next forum will take place offline, and we will have great opportunity to visit Tashkent city and beautiful, hospitable Uzbekistan. I recall, and I have to actually refer myself to that virus, but I would like to devote several words to that virus, but not from the medical point of view, but from the point of view of social effect, social impact that has been produced by that pandemic. We spent 1 year with that already. I am not a COVID dissident because 2 times, I think, I had it, and it was quite severe. You know, I don't wish anyone to feel it and to have it. That's one thing. But I specifically understand that the lethality rate, it is only somewhat about 1% of that virus. Well, seasonal flu is a lot higher, but it is a lot less that Spanish flu that happened, remember? When the whole cities would die truly. So why am I recalling all that? Why am I sharing all that? It's because I'm surprised, a little puzzled with regard to the presence of certain balance of values in the modern world. I truly think that world for the first time is faced with the following situation. I'm not only talking about part of my life truly, but also I'm knowing history, and I know a lot of history. When the matters of humanity has become the priority of agenda, even going up front comparing to economic matters. And that's good, because treating human being properly, so within recent 100 years, I would say, within 1 century, I may say that for the victory of humanity, a lot of people have died, actually. And we see that the world is now exchanging economic growth in order to promote the social aspects and humanistic aspects. I don't know what other colleagues of this event will say. Will they share their thoughts? Will they agree with me or not? But we were able to observe certain changes within the legal regulation. Let's be frank with each other. Well, decisions that has been undertook by leaders of, let's say, medical organizations or the world leaders, they were of regulatory nature. And the victory of legal rights is not there. And yes, if we say that the right and law has divine nature inside, well, we may say so too. That's philosophic. There is an ongoing transformation right now. The world is changing, and I've had this great opportunity to discuss it already, maybe during that forum, but previously, when there is a period when humanity switched from Stone Age to the Bronze Age and then to the Iron Age. So my personal sense is that we live during the period of transformation, but it will be squeezed really down comparing to the previous years. And that's very much important. And that's quite important because the whole platform, the whole basic stuff is being replaced right now, being transformed. So we're going back also to the Marx and Engels dimension. Especially, this is quite fair for those who have graduated during Soviet time, the understanding of Marxism and Leninism with regard to basis and the overconstruction. Well, that's quite easy for us to understand. So right now, the basic platforms are being changing. So, and right now we're switching to this green energy, which is also a good proof to that. And why am I saying all that? The whole understanding of law or legal approach as a social dimension within upcoming decade will be transformed as well. And for us, barristers, lawyers, advocates, because we are quite active and vivid and vibrant, we have to think about our future and what exactly the law and legal profession in the future will become, and what will be our place within this newly developed system of values. Probably, when I'm talking about that, I am probably resembling you one biblical personage and those colleagues who grew up in Christianity, and not only Christianity. They probably know that short story when Jesus said to the Paul, there will be 3 times when rooster will give the sound, and then you will betray me. And that's true, by the way. The whole system of values is right now being transformed. Right now, it is still a lot of time until the sun goes to rise, but the first sign has been already given to all of us. We have to be able to see the signs, the 3 signs, which will become quite a flagging one for us. And by the end of that time, the rooster will become a broth. But we will have to be ready for that. The reality that we faced during pandemic, they produce even more reasons to think of the transformation of law. I'm pretty sure that the world after pandemic will be different. We will not be back to the 20th century. We have to be in full understanding that there should be completely different place of defense attorneyship and lawyers in that new world.
So we have that concept of artificial intelligence where, like, you will not need an army of lawyers. I don't want to repeat myself, but 2 years ago, actually, I used different words and a different perspective. And I also delivered the message at that forum. But in fact, we need to get down to earth, and say that digitalization and every global process, first of all, means the budget, state budgets and corporate budgets. And they will be used, these budgets, and at a large scale. And I guess also there will be a willingness to develop an artificial lawyer. Believe me, when you have an army of digital experts, when you have a budget, why not think about developing an artificial lawyer? In fact, in that sense, I'm a little bit optimistic, and I am sure that the profession of a lawyer will remain until people facing a difficult life situation regulated by legal provisions. Well, here we will need empathy. We will need the human dimension of that problem. But really, there will be fewer and fewer legally important aspects in the future where you will need empathy. Even now, today in Google or in Yandex, if we are referring to Russia, you can ask a question like how we can address any given legal objective, and then you will be given an adequate answer. That's the reality of today. And that's why, with due credit to the traditions of our profession and our special position in the system of upholding human rights and legal values, so we have to start considering in a serious manner our position of the bar and the future system of values and future understanding of what the law is. At this forum, repeatedly, 1 or 2 years ago, and even after me, the rule of law as a concept was mentioned. And it's an important concept. It's an important phenomenon. And I understand why our colleagues from Anglo-Saxon world are promoting that concept. And we would like to say thank you to them, because they remind us about the need for the rule of law. And to finish my presentation, I would like to say about a very important detail, a detail that can determine a lot of things. And it's not only me, my colleagues also have mentioned the independence of the Russian, I apologize, well, independence of any bar, Uzbek, Georgian, Azerbaijani, Polish. So by independence, first of all, we mean independence from the influence of the state, and the fight for that independence was traditional, and it's all clear to us. But also there is another element of independence which we have to keep in mind, and I have sincerely mentioned that and mentioned repeatedly. So we are grateful to our colleagues, first of all, to colleagues from the US, from England, who 30 years ago, during the establishment of the present-day Russian bar, provided us invaluable assistance. So you taught us, back then we were Soviet lawyers, you trained us in like what the legal business is. You told us about marketing, because from you we learned like what those concepts meant. We even learned how to use those concepts, sometimes abusing the trust of our clients, but a lot of necessary things were given to us as part of our profession by our foreign colleagues. But in such a situation, an understandable phenomenon occurs when parents cannot live with the fact that the children they have taught for many years have become independent, and they all have their own understanding, like what is good and what is bad. And from this, we are having this phenomenon which is well described in classical Russian literature, and Mr. Turgenev in his novel Fathers and Children. Actually, this is the title of that problem, Fathers and Children. And that's why I want to highlight this very circumstance, the need to preserve mutual respect to each other, and mentorship or teaching should never become mentorship, and the people having a sense of style, and when they know their limits. I guess you understand what I mean. So I wish this forum every success. Hopefully there will be discussions, and maybe I even tried to focus on that deliberately. And if any colleagues react to my message, I will be happy, because I don't really like when people only report on their achievements. I like the forums when people can debate, can agree with something or disagree, and that's why they get together. Dear colleagues, thank you so very much for finding an opportunity to hear from me. Hopefully you listened attentively. So I shared my concerns about the redesigning of the world, and as a result, redesigning of the law as a social phenomenon. And it's essential that we, the bar, could find the place in that new world, keeping in mind, first of all, the fact that we have to maintain that status of our profession as an elite profession, because being part of the bar should sound as proudly, I'm a lawyer. And the second point is that being part of the bar should enable us to feed our children, to live a decent life, and that's actually the most important part. So we have to preserve it and maintain it in the bar, no matter if it's the English or Russian, German or Uzbek bar. Thank you so very much for your attention. Thank you. I'm with you. All the best to you, colleagues. Thank you so very much, Yuri Sergeyevich, for your very interesting speech, for sharing your ideas, because you have the moral and the scientific right to share your ideas, and they are very interesting to us. We are grateful to you. I think development of these ideas will happen soon, because the profession of a lawyer is being transformed even today. And maybe your concerns look quite optimistic. Maybe tomorrow or even today that time will come. The floor for the next, no, I will give the floor to James Siglin so he could introduce the next speaker.
Thank you very much, Davron. Our next presenter is attorney Valden Tesk. She's the president-elect of the Minnesota chapter of the Federal Bar Association. And she will tell us how the Federal Bar Association works to improve and support the judiciary and the bar. Ms. Tesk, we are very pleased to have you with us. The podium is yours.
Thank you, and good afternoon. As James just introduced me, my name is Valden Tesk, and I'm actually now the president of the Federal Bar Association in the Minnesota chapter, and I'm a partner in a private law firm, and my law practice is focused on complex litigation and class actions. As a result, I do much of my work in the federal courts across the United States. And I want to thank you for inviting me to speak today to your group. It's truly an honor to be with you from across the world. That is one of the advantages of this pandemic, is to be able to appear by video easily. And I'm very glad to be here. Although I've been in the United States the majority of my life, I actually spent the first 10 years of my life in Western Asia, in Turkey, not too far from Uzbekistan. My topic today is about the role of bar associations in the United States and how my particular association, the Federal Bar Association, or FBA, as I'll refer to it during my talk, how the FBA serves our legal community and the legal profession. And I'll talk a little bit about how the Bar Association supports our judiciary and, importantly, how it supports the rule of law in our country. So I'll start with kind of the background. What is the FBA, the Federal Bar Association? Well, the FBA, quite simply, is an opportunity and a platform for lawyers and judges to collaborate on projects to benefit the legal profession. It's completely voluntary, as almost all bar associations are in the United States. And it started as a very small organization in Washington, D.C., over 100 years ago, to provide a way for federal lawyers and judges to get to know each other in a non-adversarial setting. To exchange ideas, to discuss the law, and also to socialize and get to know each other. Over the past century, it grew into a large professional organization that included not only members in Washington, D.C., but also members all over the United States. The FBA currently has over 18,000 members, which include lawyers who litigate in the federal courts as opposed to the state courts. These lawyers work for both the public and private sectors. And it also includes law students, federal judges, court administrators, and law professors. The FBA currently has over 90 chapters around the United States. Most of them are located in larger metropolitan areas, but we do have coverage throughout the United States. I'm the president of the second largest chapter in the country. That is the Minnesota chapter, which has around 900 members. I joined the FBA when I was a brand new lawyer, and I've been involved with it for over 25 years now. And over those 25 years, I've had the opportunity to participate in a number of projects, programs, initiatives, and have held a number of leadership positions within the organization. So how does the FBA do its work? Well, the FBA is an organization, like many, that primarily accomplishes its mission, which, by the way, is the advancement of the administration of justice. It accomplishes its mission through the many sections and committees that it has. The national organization does its work through sections that are focused on specific substantive laws, and the local chapters, such as the Minnesota chapter, do their work through the committees and various officers that are elected annually. The Minnesota chapter currently has 20 different committees, and each of those committees is populated by a number of lawyers and judges and law students. And each committee is led by usually 2 or 3 co-chairs. Those committees include substantive law committees, such as, I'll give you a few examples, the Intellectual Property Committee, or the White Collar Criminal Law Committee, or the Complex Litigation Committee are just a few. We also have a number of committees that focus on the improvement of the legal profession. One such committee is the Diversity and Inclusion Committee, which is actually our largest committee. Members of that committee work on initiatives and plan programs and educational seminars which focus on diversity within the legal profession, as well as legal issues facing diverse populations within our country. That committee plans and runs approximately 20 different programs each year. It's a very busy group of lawyers and judges. We also have monthly luncheons within our organization where we invite a lawyer or a judge to speak to the group about current legal issues each month. It's a great opportunity to learn and improve our own practices and to exchange ideas on a regular basis. And it also helps with civility when you sit across the table having a meal together and have conversation before and after the meal. Those are important times for our profession, to be able to be together. Another committee that focuses on improving the legal profession and helping lawyers is our mentorship committee. This group matches law students with experienced lawyer mentors. It also matches college or high school students who are thinking about going to law school with mentors that can help them through the process and give them advice. This committee has matched probably over hundreds of lawyers with a variety of law students and young lawyers over the years. And those relationships usually continue on beyond that initial year of mentorship. We also have groups within our organization that focus on outreach efforts that are geared toward the public, not just the legal profession. For example, we have a community outreach committee that partners with the federal court, including majority of our judges, to plan and provide a week-long camp for high school students to introduce them to the justice system. These high school students spend each day in the courthouse taking part in educational programming and a variety of opportunities that our committee members plan for them. They meet the judges, the clerks, the court reporters, the bailiffs, prosecutors, defense attorneys, and other court professionals to learn about their jobs. They participate in mock trials in which they play a role, and each of the federal judges takes turns in talking to the group. This is a way that our organization can help demystify the justice system for our younger citizens and help them to learn about the law and potential legal careers. This positive exposure to the legal system also helps engender respect for the rule of law. We also have a number of committees that assist with day-to-day administration of the Bar Association. We have quite a few lawyers that are working within our, for example, our Digital Communications Committee, which prepares all of the email and social media communications to our members about our events and programs. We have newsletters and a number of other communication tools to make sure that the bar is in contact with each other and know about the various events and opportunities. And in addition to these educational seminars and a variety of more serious opportunities that the Bar Association plans, we also have several committees that plan purely social events for our members and the legal community. One such example is our annual Federal Judges Dinner and Dance event, which is a formal gala-style event that has become the highlight of the year and very, very well attended. It's an opportunity, again, to get to know each other in a much more social and relaxed setting and enjoy each other's company in a non-work environment. And again, this does help to increase the civility and the professionalism that then carries on into our everyday work lives. So what benefits does the FBA provide to the profession and the courts and the community? All of these 20 committees I described are run by volunteers who are lawyers and judges. They give their time freely and they co-chair committees. They've served as past presidents of the organization and they speak at educational programs. In our chapter, we've been very, very fortunate to have the active participation of many of our federal judges over the years. And the lawyers and the judges get to work together on all of these endeavors. This leads to more collegiality, more civility, and certainly more understanding among our profession. And this is probably the most important benefit of participation in Bar Association work. And it's also the reason that so many of our members give many hours, sometimes hundreds of hours of their time to volunteer for these projects and for leadership roles. And you may be wondering about the potential for conflicts of interest, or at least the appearance of conflict of interest when judges and lawyers interact in this way. When they work together on projects or they co-chair events together. And that is a very valid question. All of the lawyers and judges who are leading or working on our committees understand that there is never any discussion of specific cases, and we take active steps to make sure that no lines are crossed that could even give the appearance of conflict of interest. Another benefit the FBA provides to the profession, the courts, and the community is the advancement of the law and current issues affecting the law. By bringing together experts in their fields and fostering discussion of current issues, the Bar Association helps lawyers and judges advocate for and make needed changes in the law. These educational programs make lawyers more competent, They make lawyers better advocates. And all of this serves the courts and serves the greater public. And it gives the public more confidence in our justice system and in the profession. Another thing that the bar associations can do is take positions on and educate on difficult current issues facing our country. These issues are, on the news every day and are on the minds of, those that are in the legal community and beyond. Taking active steps to discuss these current issues leads to betterment of our society and leads to better justice. Bar associations can speak out against injustices. This is another important role for our organization. And our associations give lawyers the opportunity to take on important leadership roles. Although serving the bar takes a lot of time, it's an important endeavor. Lastly, the courts benefit because the judges and the court administrators can communicate directly with the legal community and contribute to the advancement of the law in a collaborative way. And so, in closing, bar association work is truly what we call a win-win proposition. The profession and the justice system all improve as a result of the collaborative efforts of everyone involved. I'm proud to be a part of the work of my bar association, and it truly has been one of the most positive ways that we can impact the larger community and more specifically our profession. I'm happy to answer any questions you may have. And again, thank you for inviting me to speak to you.
Thank you so much, Ms. Tesk, for that very interesting discussion of what the Federal Bar Association, the many aspects that it contributes to the courts and to the bar. I would say before turning this over to you, Davron, that we've been asked to be mindful that we have to end exactly on time because our wonderful translators, Malika and Veronica, have to be transported to the next venue for the upcoming panel for this forum on judicial independence. So with that, thanks again, Ms. Tesk, and I now turn it over to Davron to introduce our next speaker. Davron?
Спасибо, James.
Thank you very much, James. I'd like to introduce right now the chair, the head of National Bar Association of Ukraine, Lydia Izovitova. Lydia Pavlovna will tell us about managing that volume of work, that burden of work, which is being put onto National Association of Lawyers. Indeed, digitalization and management of National Bar Association, that's the topic which can be quite helpful for the National Association. In our case, it is the Chamber of Advocates in Uzbekistan to cope with those tasks that will be expressed by Mrs. Izovitova. Good afternoon, esteemed participants. Thank you very much for inviting me for this forum. It is my great pleasure to see my close friends, really, those who I work with for several years, for many years, I would say, and some hypothetical friends, because in spirit, we're all friends. And the only thing we are missing here is direct communication, offline communication. Just like Yuri Sergeyevich, 2 years ago, I've been to Tashkent, I've been to Uzbekistan. Trust me, those who haven't been to Uzbekistan yet, you have to know, Uzbekistani people, it's not ethnical group, it is civilization. You have to go to Samarkand to feel this. You have to visit to all Asian cities, and I lost her actually. Huge and in-depth history and significant history lays behind these people. My warm regards to all my friends in Uzbekistan. Those who I met 2 years ago, we made our strong ties, and we keep communicating, keep corresponding with each other until now. I don't want to brag, but the concept that has been voiced today in developing the bar in Uzbekistan right now, and that fight for independent bar of Uzbekistan is very much dear to my heart. In 2012, in Ukraine, there was this unverified story that the law on bar and the activities and actions of advocates has been adopted. We have professional organization, independent organization of lawyers, which up to date brings together 60,000 lawyers, and membership is an obligation with us. The state is not interfering, and it's not managing lawyers. In each and every region, we have the Council of Lawyers, and that's 27 regions. In each and every region of our country, we've established our own qualification disciplinary commission, which counts for 2 chambers, qualification and disciplinary. So the only advocates are part of that. The access to the bar profession, to the profession of lawyer, is defined and provided only by those chambers. So each and every region elects their own leaders at the conference. We also have a leadership or management of National Association. Under the Council of Lawyers in Ukraine, well, we have 1 members from each region, which are being selected or elected during the conference. And I am the chair of National Association of Ukraine, and I have 2 deputies. We have been elected by direct secret voting by the Conference of Lawyers of Ukraine. What is very much important today? It is important today to have balanced system of bar between the center and the regions. It is completely independent from the state. We do not receive any budgetary funds from the state. We are self-sustained. Within all this time, we've never received any financial support from any international grant or donors. We would even reject in order to support our independence. Within 8 years, we've had different rotations inside of our core cadre. However, we follow the objectives that we have. We pursue this sustainability. So within these 8 years, and I lost her again, we were able to develop and establish the rapid work of our self-governance bodies. In order to further develop our work, I will try to cover the strategic areas for further development of our bar association. So one of those were the project and digital area. So you cannot manage today without digitalization, especially during the period of pandemic. So at the level of digitalization, bar association in Ukraine, by objective assessments of our colleagues, goes in front of many other of our colleagues. Like, for example, legislation puts certain burden to the council to have a single registry for lawyers of Ukraine. So, and we have it digitalized. So it is open. There is public access of any citizen to that registry. It is an official registry, and I will try to show you a very short presentation. Let me share my screen.
Отключил демонстрацию.
Okay, I'm trying to share my screen. Can someone provide me with this capability, please? No, it's not working. So for the participants, the capability to share screen is turned off. Dear colleagues, someone will have to provide.
I believe if the host right-clicks on your image, it can make you the host.
She has to be a host to do that. Yeah.
Вот мне такое право мне не дали, поэтому я буду это делать без... Попытаюсь. Оп, есть.
Отлично. It works now. That's it. Thank you.
Нет, к сожалению.
Мы видим ваш экран.
Interpreter tries to explain how to share the proper screen.
Так. К сожалению. А вот так видно? Видно.
Good, great, we have it. In January 2013, and before that, we did not have that feature. We initiated the single registry. So that's the profile that covers the information of each and every lawyer, and each and every lawyer, or each and every national of the country, by second name of the lawyer may find one. Under the registry, we have all the lawyers of the country with their certificates, valid certificates or licenses, when exactly they've got their right to practice the law, and all those who would want to have this opportunity online, they may find information about any lawyer. So here's the search feature. How can you enter the single registry, Yerau? So you may put name, second name, patronymic, number of certificate, how he has got his license or certificate. And I've lost her voice, I'm sorry. So then you click search, and here's what we have. Here is the profile with all the data. The client is able to select the lawyer. So if he or she is okay with the years in job, then professional experience or any other data can be obtained from the profile, and you may select the person you liked. Further, we think that the profile of the lawyer is his or her business card. Now, further and further. As for the personal cabinet or office of the lawyer, each lawyer has digital personal office. So in that personal office, he or she may pay his fees, membership fees. Using this office, he or she may register in or to get training at the higher school of barristers. From that office, he or she may generate an order to provide or warrant to provide legal assistance, and then to participate in certain case. They, like previously, they would always need to have it from the region. Right now, each and every lawyer can do it himself. He can develop that warrant just online. This is what it looks like. So this document is unique. Part of that is being filled out automatically. It takes the information from the profile of the lawyer, and all the rest, the name of the client and everything, is filled out manually. So this is how lawyer to client privilege is being kept. I'm very sorry, I'm losing her time to time. So because we have this unique PR code, it gives you an opportunity to look through the profile by scanning with the help of a smartphone. So there are exclusive authorities given or delegated to the Bar Association. So building capacity and refresher training is also done by us. Using personal office, the lawyer may get registered to be part of a training course, for example. And starting from 2019, building capacity or postgraduate or continuous education is not only the formal requirement for the active lawyer. Like before, we didn't have good opportunities to check if the credits are being verified and truthfully entered. But now we understand that the profession of lawyer foresees constant learning process, and building capacity and continuous education is an obligation to the client. So the person would truly want to have quite a competent defense lawyer. So the Council of Lawyers in Ukraine decided to establish a platform for refresher training for continuous education for lawyers.
So here we have data on all the activities, and actually we also have data on all those that were accredited against specific criteria. And for those online events, we have established online registration. She's frozen. And during the pandemic, that resource was very helpful to ensure continuous legal education, and in some areas during the lockdown, even more activities have been conducted. She's breaking up, I'm sorry. Compared to face-to-face education. And thanks to such technical opportunities, online registration, and in 2020, we conducted 2 activities with the Federal Chamber of Lawyers of Germany, and several lawyers from Ukraine interactively participated in such activities online. And every year, after professional development, a lawyer gets a certificate indicating the score, and automatically that information is entered to the lawyer's profile, to the single register of Ukrainian attorneys. Thus, we have automated collection of statistical data, and at the regional, national level, and at the level of each individual attorney. And when we launched our online platform, we could see its benefits. In addition to the benefits I've mentioned, I'd like to also highlight the quality of education. We have introduced the online webinars with interactive communication between the audience and the lecturer. Also, there is no opportunity to buy extra score to get certified, and clear rules have been established for the lawyers. And soon we plan to develop the products that would make possible similar training for assistants of lawyers, and there will be also functions performed by the chamber, so many of them will be available online. And during the pandemic, we initiated synchronization, so electronic courts are being introduced in Ukraine, and so now this process is synchronized with our processes at the Chamber of Lawyers, and access will be given to individual accounts, to relevant individuals. And in Ukraine, also in criminal proceedings, an opportunity is given not only to participate remotely in proceedings via our platform, but also fees could be collected, motions could be submitted, information on the schedule of proceedings is available, and the status of cases. And the system makes possible exchange of documents among participants in the proceedings, and procedural documents could also be given to participants via the electronic platform. So notifications could be sent in the format of SMS, and so that system should be integrated with the National Register of Ukraine. And so we enable the advocates to have that identification with the system for advocates. Now I can hear her, and then so an email will be used, which is indicated in the profile generated by the Chamber of Advocates. And currently, the electronic court makes it possible for an advocate to generate the electronic order to get access to case files. And also to electronic power of attorneys. And dear colleagues, now we are living in the times where information technology is developing rapidly. The world will never be the same again. And so, and as for that new world, we have to adapt that new world to our professional needs. So the Bar of the Ukraine, as we see it, has successfully introduced quite a few technological solutions that make it easier for citizens to get access to legal aid. And they target also the professional legal community. So we're willing to share with all of you our practical experience to help make our profession better adapted to the settings of the present-day world, so it is more competitive and more effective. Thank you, everyone, for your attention, and I hope our next meeting will be an offline meeting, and I will see each of you. I will be happy to see all of you in Ukraine. Thank you very much, Lydia Pavlovna, for such a brilliant presentation. In fact, yes, we have a lot to learn from our Ukrainian colleagues. And I guess I can safely say that soon we will definitely visit Ukraine. We'll be happy to see you, and to share experience. Now I would like to give the floor to James.
Thank you, Davron. We will now hear from attorney Thomas M. Bonds, who is the president-elect. I think, Thomas, you are still in the position of president-elect of the Massachusetts Bar Association. He will share with us the important collaboration and cooperation his association does with the courts, the legislature, and the profession. Thomas, the podium is yours.
Thank you very much. Am I able to share my screen?
We hope that you can, and
yes, I believe I can. I'm Thomas Bond. I've been in private practice in Boston for, let me get over here first. I've been in private practice in Boston for 36 years. We have an office in downtown Boston. And president-elect of the Massachusetts Bar Association now. I want to thank, first of all, the Chamber of Advocates for inviting me. I want to thank Ambassador Rosenblum. I want to thank Davron and James and Petra and Musa. And I'm always afraid when I start naming people that I'm going to forget someone. So I think I have everyone, but thank you so much. Maybe next year, and I've always wanted to do this, I can visit your country and I can eat my way and walk my way and drink my way along your beautiful Silk Road. So I'm looking forward to that. We have essentially three bodies of law and three organizations, and it's important to try and get them to work together. You know, we've got the state legislature, which passes the laws. We've got the courts that enforces the laws. The courts interpret the laws. The governor's office, which enforces the laws. And we lawyers, we have to live with the laws. We have to advocate using those laws. So let me tell you how the Massachusetts Bar Association does it. First of all, we are 10,005 members strong. We mostly consist of lawyers. We have continuing legal education programs. We have a whole host of things. We're organized into groups, practice groups. We have employment group, a criminal group, a diversity, equity, and inclusion group, different groups. But my favorite aspect of this is when we see a problem, we solve a problem. So I want to tell you a story of how that works in this one particular instance. Here's the trial court here, and here's a picture of the trial court. That's the John Adams Courthouse on the left. That's where our courts sit. And everything in Boston is within maybe a quarter mile of each other. The Mass Bar Association building, the legislature, and the courthouse. So let me tell you a problem that we were facing in Massachusetts. People were being incarcerated because they couldn't afford to pay their fines. They couldn't afford to pay fees, and it wasn't right. So our criminal justice section working group, what they do is they form into a working group and they come up with a resolution. I'm going to show you the resolution in a minute, but this resolution essentially is something that goes before our governing body, which was within the Mass Bar. We have a House of Delegates, and it's voted on. So this, it's a resolution, and basically it says that you shouldn't incarcerate someone if they can't pay their fees. Because when we looked at it, it was mostly low-income people who were being incarcerated. That's not fair under our justice system, and I hope not under anyone's justice system, that if you can't pay your fees or your fines, you're incarcerated. So we said, look, let's have a law. Let's develop legislation to give people the right to a court-appointed lawyer, to give people alternatives to incarceration. Maybe they could do community service. Let's take a look. Let's give them a hearing to see if they're not paying because they can't pay, or if they're not paying because they're willfully refusing to pay. So we put it before the House of Delegates. You know, everyone votes, big room. It was unanimously approved. So what do we do then? The next step is we take it to our state legislature. That's a picture of the State House in Boston, beautiful building. And that's where we have two chambers in there. We have our House and we have our Senate. And we also have our governor's office. And I think the governor's office is right. If you can see where I'm pointing, maybe you can't see on that screen. And the governor sits in there also. So we draft a bill, they call it a bill. And the important aspect that we have is we are blessed with probably the most important lobbyist in the state, a fellow named Marty Healy. And Marty takes this bill and he walks it up to the state legislature, and it's got to go through committee, and it's got to be, it's got to make its way through both the House and Senate, because both chambers have to agree. And what we do is we'll testify at the State House, at the legislature, concerning the bill. This here, I mean, this was really what we call an omnibus criminal bill, bail reform and different things. But what I've highlighted is what I wanted to focus in on today: reducing the criminalization of poverty and fine time sentences. Let me get over here. Yeah, in review of bail for inability to pay, and we testified before it. And in the end, after it was passed in the legislature, then we work with the governor's office. And the governor's office has legal counsel, and nothing is final until the governor signs off on it. Well, in this case, through our efforts, the governor did. And here's the body of law that was enacted. It was Chapter 127 of MGLE. It's the Mass General Laws Association. The highlights of the bill: free counsel, and you get a hearing to determine if paying this fine is going to cause you hardship. Alternatives to incarceration, so that people aren't jailed for failing to pay their fees or their fines. And please, don't commit anyone under the age of 18 years old. So we're proud of how we collaborate with, and cooperate between the legislature, the courts, and the governor's office. And we think it's so important as a bar association for you to develop contacts within those so that everyone can work together. It's one justice system. We all have to work together. So again, thank you for your time. See a problem, solve a problem. The Bar Association can play an important role in passing legislation. Thank you very much.
Thank you very much, Attorney Bonds. That was a very, very relevant example of what your association has done in terms of addressing a much needed need there in the state of Massachusetts. So thank you very much.
Thank you.
We will now hear from Ms. Maria Slazak. She is the president of the European Association of Lawyers. And Maria is going to tell us about the importance of international cooperation for the development of the legal profession. Ms. Slazak, the podium is yours. Thank you.
Let me stop sharing my screen here.
Thank you, Thomas.
I think that now it's okay. Can you hear me?
Yes.
Okay, thank you very much, James, for introduction. And I maybe will say at the beginning a few words about the association, which I have a pleasure to represent here. The association was established in 1986, and this is called European Association of Lawyers, but we are open globally, I can say, and we have really the members from 4 continents and till now from 26 countries. The association was established by the European Union lawyers, and one of the ideas was to, first of all, to promote the values of our profession, and secondly, also to build the network. And one of our, I would say, flagship project in last 3 years is so-called Twinning of Lawyers. Within this Twinning of Lawyers program, we cooperate very actively with Uzbek Bar, which is a real pleasure because lawyers from Uzbekistan participate in our events. They are the speakers also at our events, and we as well, we invite them as the members of our committees. That there is very good cooperation, and if you allow me, I know that we are very short of time. I had slides, but I resigned from them, and they are in hands of organizers. They may make them available for those who really will be interested in, because we have to leave some time for questions and some to other speakers. This, but allow me to say a few words about this Twinning of Lawyers. This is the idea to get lawyers together from all parts, from East and from the West, just to learn from each other. And one day of this 2 and 3 days of the meeting, this is always one longer weekend, once a year, we have the 1 day scientific, and then the rest of the time is also devoted to certain social programs, which, as Wilden very rightly said in her speech, that the social programs are not less important than the scientific programs, because in less formal conditions we can pass very important messages. We can, in personal contacts, share the opinion on various issues. As you said, I decided to speak about the relevance of international cooperation for the development of our profession. And I will share this for two areas. One of them is that to be defended by international community in case you have the problems as the bar or as the lawyer. And secondly, just to share the experience and to learn from each other and to increase our competences. With this to be also protected to some extent and defended by the international community, I would like to mention, and I'm very pleased what I heard today at the very beginning of this event from Mr. Diamshit Turdaliev, if I did not make any mistake with the name, that when he showed us the changes, amendments to the law, and that all values of the profession in Uzbekistan are really covered by the law and protected by the law. Because we have to remember that we lawyers, we have the mission to perform our task. It's not the same what entrepreneurs do. It is not the way of earning money. And because of that, we require that our independence plus the real confidentiality, the contacts between lawyers and their clients are fully respected. And as somebody from us already said, it is not in our interest. It is not in the interest of lawyers. It is in the interest of the society of people because and citizens, because citizens, if she wants to defend their rights, they should have the person with whom they can talk, very openly. That we will, and then the other within our mission is also the real support for the access to justice, the access to justice, to assure it, because we know that sometimes this access to justice is quite theoretical, not the real one. And what we understand by access to justice, right to the impartial and independent court, the court which will fully respect the equality of arms during the process, and it has been also said by Jamshid earlier. And the other thing also, to develop in the country legal aid system, the system for those people who cannot allow themselves to pay all the costs of legal court fees and also legal support. And this legal aid system should be financed by the state, not only because not only in the court proceedings, but also to give the advice to citizens when they need the legal advice when they need it and they cannot afford themselves. And what would be the methods in this cooperation of just to give the protection to this, what I said in this field, the field of the protection for our mission. We should have the seminars, conferences, which are and then exchange our experiences. And also, if there are some difficulties, there are a lot of international organizations which will, with a pleasure and with full engagement, will help lawyers who are in certain danger, or if the bars, if they need some support. On these meetings, it is very also important. It is important to exchange the best practices, because in this country you can work out one practice in the other one, and it is important to share this experience. And if there is something like that, you can count that international community will express their support. They will write the letters to the authorities. They sometimes go as the observers to the trials if there is something that maybe the court is not fully independent or impartial. Those are the real and also sometimes demonstrations to support the certain lawyers if they are in real danger. I would like to mention in this context that nowadays there is in process Convention on the Profession of Lawyers, which will be issued by the Council of Europe. And this convention will create certain binding instruments that, in case the states do not fulfill the requirements of the law, then they might be, if the country will sign the convention, that they might be to a certain extent forced to do it. As regards this, the meaning of international cooperation for improvement of equality of our work, this is the forms of it are like also conferences on substantial law, seminars, various exchanges between lawyers. Does the young lawyers go to the offices in the other countries, and then they can learn from each other for the comparative law, and also to understand better and new technologies, because in some countries maybe it is neglected, in others it's more developed, this paperless law firms and so on, and also using the new technologies to remember about human rights issues, that this is very important and very much connected. And those contacts between the lawyers within this network are very important also for our everyday work, because if you have quite a lot of contact, it is easy abroad, then it is easy very initially to call to your colleague and to ask, could you give me initial advice to discuss a little bit. All of that is important for our development, and we really have to work, all of us, on it. And one word to Uzbek lawyers, that thanks a lot for inviting me for this nice and very important conference. And as many of you expressed that willingness to be one day in Uzbekistan, I'm in this group because your Bukhara and Samarkanda is well known all over the world, and it was always my dream. I haven't had a chance yet. Thank you very much.
Thank you very much, Ms. Slezak. Your comments about the important role that lawyers play in ensuring access to justice were very important, and it's duly noted here. At this time, I'll turn it over to Davron to introduce our next guest. Davron.
Спасибо, Джеймс. Я с удовольствием представляю.
Thank you, James. It is my pleasure to give the floor to Anar Bagirov, the chairman of the Azerbaijani Bar Association. Our chair of the Chamber of Advocates, Ali Mirnazarov, when he visited the Republic of Azerbaijan, he was deeply impressed by the achievements of our colleagues in Azerbaijan. So he is conveying his best regards. Now he is sick, but he's recovering. And Anar, the floor is yours. Thank you so very much. First of all, I would like to thank you on behalf of Azerbaijani advocates and the Bar Association of Azerbaijan. I would like to thank our Uzbek friends, and I would like to congratulate them on the successful second legal forum, Tashkent Law Spring. And I think that it's an important event in the legal life of our region, and not only our region, but we can see also representatives from many countries being active in the forum activities. And I would like to wish sincerely, and I would like to express my sincere support to our Uzbek colleagues, and I would like to express my regret that Dr. Ali Mirnazarov can't participate personally. So colleagues, please convey my best regards to Ali. And of course, I will contact him afterwards, and I will try to talk to him personally.
We've had beautiful presentations around this table. I'm so happy that my dear colleagues, who I respect so much and we collaborate so strongly, they've expressed their opinion on different aspects that are of a great interest, not only for the legal society of Uzbekistan, but also for the country of Azerbaijan. Those reforms which are ongoing within the legal and justice system in our brotherly country of Uzbekistan are very interesting for us, because to a degree we also live through similar challenges in our life, in our activity. So we were all part of Soviet Union. We are all post-Soviet countries, and we started up our work at the same time, I would say. Within this period of time, some of us were able to achieve certain significant success. Maybe that's due to different factors. Some of us are trying to chase those lost opportunities, but representatives of the law profession, legal profession of post-Soviet territory, we better understand problems and challenges of our colleagues. So that's why I'd like to identify those matters which will be of an interest. That's our experience, how we see the establishment of strong independent bar, and how one of the main components of justice can be well developed. And that's quite an exclusive significance for the legal system of any country. In Azerbaijan, until recently, we had a lot of challenges and problems, both in the number of lawyers and the efficiency or efficient functionality of the professional association of lawyers. My colleagues from post-Soviet countries, they're probably well aware that there are matters maybe linked to improper regulations provided for the activity of or functionality of lawyers in our countries. Unfortunately, it happens that we do not treat those matters well. Let's go back to the Constitution of Soviet Union and Uzbekistan, for example, of 1978, and Azerbaijan of 1978, and the old Constitution of Soviet Union. There are provisions in the Constitution which do cover the functions of lawyers or bar. And it was mentioned that in the republics, there are chambers or the colleges of lawyers, and they have to provide for legal assistance to any client. So in 1995 constitution that has been adopted in independent Azerbaijan, there is no specific provision that will be covering the activity of professional association of lawyers. I admit this. I am well aware about the norms of the Constitution of Independent Uzbekistan. I know that in the Constitution of the Republic of Uzbekistan, you have Article 116, and in principle, this article repeats the norm or the provision that has been stipulated in the Constitution of Soviet Uzbekistan. So, which means that you were able to cherish and to keep this provision. I'm regretting I have extra microphones on, which is bad. So in Azerbaijan, we didn't do that. So if we go back to the constitutions of our countries, that's a direct action act. And if in constitution there are provisions linked to functioning of prosecution, then indeed there should be an obligation to have a provision to regulate the activity of bar, the activity of lawyers. So it would be very good to introduce amendments to Constitution of Azerbaijan. So we will come up with a proposal to have a separate provision on functioning in Azerbaijan independent bar or a bar association. So it could be association, could be chamber, you name it. Those are just play on words. It have to be part of Constitution. Why am I saying all that? I know that normally, sometimes it happens that in our countries, some people say, why do we need this unified bar? It would be very good to disintegrate it. No, we see in some countries, they try to do this. We witness these processes. I remember the years when in Ukraine, they didn't have united association of lawyers. There were different types of small associations, and I remember how weak bar in Ukraine was. But also I was watching the Council of Europe, and they were looking into the experience of post-Soviet countries, and I'm so happy that our Ukrainian colleagues of today, they claim that they've established, they declare that they do have this association that strengthened the professional level of lawyers and made them even more independent. So I welcome all that. I praise you. So why in constitution, in the main laws of our countries, this should be stipulated? So we all witness that authorities, sometimes government or certain activists, let's say, they try to weaken bar. And divide and impere, that's the principle which acts here. So divide and rule. So that's why we have to have associations, and these associations should be strong. For them to fail, for those who want to disaggregate and to disintegrate us, they have to fail. So, and that's why we have to put our efforts to improve the situation. You know what? Currently in our country, we have the process of making our image pre-juvenile. So like before, for example, the older people would want to become lawyers. Right now, we have many young people who would want to become defense lawyer, and I'm happy because number of lawyers now has increased 15%. So in 2018, 2019, the number of lawyers is increasing 50% plus. So now the number of lawyers is increasing 15% plus. So, and that's very good. It's very vibrant. Like right now in Azerbaijan, some lawyers become judges, and we uphold place number 2 after those who worked before in courthouses. So first and foremost, I think we have to develop a very good dialogue with the government. On behalf of international organizations, sometimes I would like to be open with you. Sometimes, since I witness it myself, some diplomatic representation officers try to interfere to the activity of lawyers. And that's impossible. You cannot allow this to happen. We have to become financially independent. That's important. Independency of profession without financial integral part to that, it is not successful independency. And if there is an association of lawyers and it cannot be self-sustained, and if it needs in donor support on behalf of international organization or other states, I truly think that it's wrong. And I'm all for collaboration with all the international organizations, and we try to do this. Like before, we never cooperated with anyone. We were very closed or concise organization. But any financial dependency, it gives the shade to the real independency. So I may declare now that Bar Association of Azerbaijan is completely independent. But I would like also to dwell on the ways of getting this independence. So we've applied Turkish model for financial support, very successful. Not only fees, membership fees are paid. And our lawyers, quite independently of their link to the association, they've supported us well, which means that from each and every agreement signed, certain amount of money is being transferred to the account of association.
And also it's all documented. And this model is very effective. And thanks to that model, we can become fully self-sufficient. It means that we cover all our costs, and we have a special account where we pool the funds, and in fact now we have a considerable amount, and later on it will enable us to resolve all our problems. And now we are resolving all issues faced by our advocates, like healthcare and so on. We can fund our younger colleagues, for example, like contests among lawyers, and also we are entitled to fund social programs for advocates for younger lawyers. Why it's needed is because since we are discussing the image of the bar, so the image doesn't mean that we assign that image to ourselves. First of all, this is the opinion of the society. in our countries. And today, the society in Azerbaijan can see that the association in Azerbaijan supports younger lawyers. And before us, that was done by foreign states and international organizations. And now I approach the legal community, the students of law, and I claim that we can support any initiative. And no request was rejected from our younger lawyers. We also offer scholarship to the most active students who demonstrate excellent academic performance, and we supported them. And also we help lawyers participating in international competitions, and we also participate in many social projects annually. We provide pro bono assistance to thousands of citizens, but this is not an obligation by law. This is our choice, and we do this. And we also keep track of all these activities. We are socially active. We are represented in all social platforms, and we have a very dynamic web page and pages in social media, and we provide updates on our activities there, and we try to establish good relations with our colleagues in various agencies. And given the time limit, I do know that we don't have much time, and I can speak a lot about this. It will be my pleasure to share our experience, but of course there are aspects where our experience is unique. So far, now we have the electronic rooms or accounts. So all advocates have them, and it means that we try to keep up with the times. And if we have electronic courts, it means that electronic advocates' offices should be available as well. We are integrated in the e-court system, and also we are getting integrated into e-government. So currently all requests could be processed electronically, and you could get a response to your request. And we try to ensure a full-fledged practices in this area. And also we are fully managing and operating and providing legal aid, which is state-funded. So before 2020, we had great problems because the amounts were very low and the advocates couldn't get that assistance, timely. And our colleagues do understand to what extent that support is necessary for advocates. And we know that in our friendly countries, for example, in the Russian Federation, a lot is being done in this regard. And I analyzed the experience of the Federal Bar of Advocates in the Russian Federation. So they have advanced ideas, and I guess they will be of use not only to us, but to many of our neighboring countries. So currently what has been done is we have established the Center for Legal Assistance, and thanks to that center, starting 2020, the advocates' work is fully paid by our association, so free legal aid, and some amount is allocated from the budget, and actually using our orders, the payment is effected via banks, and that's why advocates get paid timely. But before there were a lot of delays and a lot of discontent, so why our advocates should be dependent on the government authorities. So in Georgia, as far as I know, the model is different. We analyzed it as well. So they established the public structure dealing with such issues. I believe that's wrong, and I keep saying that to my Georgian colleagues. The state should not directly be in contact with advocates in terms of payments, because it means some sort of dependence. It means I start being dependent on the state. And now we are handling that fully. And also we are developing the law on free legal aid, where citizens can get free legal aid funded from the state, not only for the cases tried at courts, but for other cases as well. So currently, we have a monopoly in that sense. So, and citizens could be represented by advocates, and you don't even understand what pressure was exerted on me when I was introducing that model. And unfortunately, representatives of international organizations some of them also argued that Azerbaijan would have problems with offering legal aid, and the citizens in Azerbaijan no longer would have legal aid. So there were such speculations. So now any person, even not being a lawyer, can represent the interests of a person at court. And then it was chaotic, and many people acted as if they are lawyers, as if they were lawyers, and that anarchy stopped completely. And now each and every citizen can get legal aid free of charge. And in cases established by law, that aid could be state-financed. Of course, we monitor the quality of that aid, and that's essential as well. So we need to enhance the trust, the public trust. To the advocates. Let me say that in Azerbaijan, the professional holiday, the day of an advocate, is what we miss in our country. I know that some countries have those days of lawyers, and they celebrate such days. And I wrote to the government requesting establishment of the Day of Advocates. Actually, on that day, the bar was established, and the president's office asked me, are there any countries globally that have that professional holiday of advocates, the Advocates' Day? And it's no secret, Ukrainian experience really helped me, because once they established such a holiday, they had the Day of the Bar. And I naturally referred to Ukrainian experience and experience of some other countries. And thanks to that, for the second year in a row, we've been celebrating the Day of an Advocate, and that's the professional holiday established by the state. And last year, the advocates who have long been active, and we have even advocates in practice since 1954 and being members of the bar. And I wrote to the leader of the state asking for bonuses, for awards to be given to such advocates. And can you imagine, for the first time in the history of the Azerbaijani bar, so on the 1st of December 2020, awards were given, state medals were given to them for fruitful activities in that area. And I guess that's necessary. We need to recognize achievements and successes, and I'm sure that you can provide awards to judges and others. But for advocates who also exercise very important functions, well, that's also necessary, because all countries claim that protection of human rights, citizens' rights is the priority to them. But people engaged in such activities, they remain hidden and beyond that process. And it means that the advocates represent the profession which should not be awarded. So the situation has to change, and we are willing to share our experience as always. I know that time is limited. I don't want to violate the time limits. And once again, I'd like to thank our wonderful colleagues, friends, and partners from neighboring countries. And I'm really happy to see you in good health, and hopefully next year we will have an opportunity to see each other in Tashkent offline and to discuss the problems we are facing. Thank you so very much. Thank you very much, Anar, for such an informative presentation. And yes, we are impressed by the achievements made by the Azerbaijani bar over a short period of time, both in terms of financing, engagement of young people, and in many other issues.
I'd like to pass the floor to my co-moderator to introduce our next speaker. James, please.
Thank you, Davron. Our next presenter is Anika Holdacroft. She is with the Justice Sector of the UNODC, and she's going to speak on the important role of law associations in quality assurance for legal aid. Anika, thank you for patiently waiting with us, and we're happy that you can join us. The podium is yours.
Thank you very much. Thank you for being invited yet again to speak here. This is my third time in your roundtables that are conducted online. I still remember the first one last year. I had to cancel the week before because then we all went into lockdown. So I really hope that the next one will be in person. Being mindful of the time, I will really try to speed up my presentation. So if you have any questions afterwards, I'm of course happy also to answer them via email. As the host just said, I work for the United Nations Office on Drugs and Crime, where I'm the focal point on legal aid. And we have heard about so many duties and responsibilities of lawyers and the help that law associations or bar associations can help them with. And I wanted to speak specifically about legal aid in criminal settings, which is the topic of my work, and quality of legal aid services and the role of associations in this regard, because as we've heard from other speakers, they can positively shape reform, they can encourage professional development, they also can encourage wider capacity development and provide guidance to the government as well, because they are on the pulse of the challenges and also the achievements of all the lawyers that they represent. And while you are all aware that lawyers are not the only providers of legal aid services, they are by far the most frequent and the most important. And we have already heard also from Mr. Bagirov and Ms. Slazak about legal aid and how your associations are involved in encouraging it and in supporting its delivery. The basis for our work in UNODC is the only international instrument that is currently available on legal aid, the United Nations Principles and Guidelines on Access to Legal Aid in Criminal Justice Systems that the General Assembly adopted in 2012, which is a soft law instrument, but a very practical one that gives states and also individual lawyers a lot of input and guidance on how to establish and deliver legal aid services. And this instrument very importantly made it an obligation for the member states, and they all signed up on it, to put in place accessible, effective, sustainable and credible legal aid systems, and to enact legislation in that regard and the regulations that need to go with it, allocate necessary resources, and also to ensure the quality, in particular those that are provided at no cost. And as we've heard also from other speakers, this can really ensure public trust in the fairness of the justice process, because if I don't have money and I get free legal services, but they are also of a certain quality, then I will feel that my needs are respected by the system and that there is in the end equal access to justice for all. I will not go into details of the right to legal aid and the rights of the beneficiaries, and I will go right to the part on actually organizing it. So bar associations, and I will continue to speak of bar associations, but I of course mean all professional associations of lawyers, however they are in the country. They have a crucial role to play to enable lawyers to work in an organized and ethical manner, and also to ensure that the services are given to all clients. And as we heard from many speakers today, the associations are either responsible for regulating the legal profession, or they are organizations dedicated to servicing and serving their members, or both. And traditionally, they were the main providers of legal aid, because they could tell their members, look, you should provide pro bono services to those people who cannot afford them. It's a good deed to society. And in many countries, they still are the main providers. And they also now are fulfilling other roles. They can, for example, ensure that there is proper coordination and communication with police and law enforcement to ensure early access to legal aid, so they can provide hotlines of their members where it can be ensured that someone at all times of the day can service a police station, for example. But as the principles and guidelines also imply, bar associations cannot be the sole providers of legal aid, simply because the demand usually is bigger than the number of lawyers or the number of active lawyers that is servicing those people. And there is just need to also supplement with other legal aid providers, including in some cases and for specific activities, paralegals and other providers such as NGOs. But the principles and guidelines recognize the important role, and they recommend that states develop partnerships with bar associations to ensure nationwide coverage, that they establish rosters of lawyers for police, court, and prison legal aid schemes, for example, and that they consult with them on accreditation, including on paralegals and other non-lawyers. And as we've also heard many times, and I will keep saying it, a strong bar, of course, is important for ensuring the independence of lawyers, which in the end is a key requirement for ensuring quality. Because if I'm oppressed, if I am sanctioned for certain behavior, I cannot provide the best service to my client. Important is to see the legal framework for legal aid, and many countries have adopted a dedicated law on that really provides the basis for delivery, defines the duties of legal aid providers, and also quality assurance mechanisms. And in Uzbekistan, you are on a good way to do just that. And over the years, you are very diligently reviewing your draft and adjusting it to the things that happen in the country and what you hear from your members. So it's very important, and it's very good to see that the Chamber of Advocates is playing such a strong role also in supporting the drafting of this law. And the approach to quality assurance, once there is a basis, it depends on how legal aid is organized in the country. And in many countries, there's a legal aid body. In other countries, there's a contracting relationship between the legal aid body and then individual lawyers that work for it, or maybe a public defender service. And there are lots of tools for practical quality assurance. And if you're interested in reading about all of them, I would recommend you have a look at our handbook on quality. I will not go into details. It's available in English and Russian. But in the countries where legal aid services are provided under contract, there, no matter who is the contracting party, you can build quality assurance into the contract. Or if there's a public defender's office, or if lawyers need to register somewhere, you can then do that. But if there is no arrangement, of course, quality assurance is often left to the bar associations, who do, in some cases, not even want to be the sole quality assurance body, because they, of course, have other duties to fulfill towards their members. They mostly deal with disciplinary action for misbehavior, for unethical conduct, but they do not necessarily go into detail of reviewing every individual lawyer's performance. So the best way to go about it, in order to use resources in the best possible way, is to combine different aspects of overview and of assurance. And in cases where there is a legal aid body, and I understand from the discussions in Uzbekistan that there could be soon the legal aid center that is established by law, then of course this legal aid body can work together with the bar association, and they can cooperate. And the most important of all the aspects is to set quality standards that the legal profession agree with, because many of them will deliver legal aid services, whether pro bono, whether through being paid or contracted by a state institution or by an NGO. So it's important that the views of lawyers are heard. And in many countries, the bar association is very active in this regard. Some are in charge of general quality of legal aid services, views, and shaping policies and politics. But in other countries, they also take action. For example, in the Netherlands, while there is a legal board that sets the policy and that is organizing legal aid delivery, if a lawyer doesn't fulfill certain standards, then the disciplinary action against this person, even though it's not in the end a disciplinary manner, but it's a non-performance according to quality standards, this goes back to the bar association, because the board can just remove the lawyer from the list of lawyers, but it doesn't have any other powers. In some other countries, there are separate mechanisms for assessing performance of the legal staff that is on legal aid, and general complaint mechanisms. So in the end, all lawyers are subject to codes of conduct, but for legal aid providers, there can be additional and more specific rules. For example, that they are not allowed to receive payment or other forms of compensation from their lawyers, and other very specific areas that other lawyers normally do not touch upon. So quality standards are really important, because it not only gives practical guidance on how to approach a case, how to work with a client, but also on how to organize themselves and what is conducted, what is supposed to be, let's say, a high standard, or at least an average standard of quality that they should achieve in their daily work. And these standards that are in addition to the normal code of conduct could be a specific code of ethics, a practice code, checklists or protocols that legal aid providers have to complete at different stages of their work. And the independence of lawyers is very important in this regard, because in order to carry out their work effectively, freely, and independently, states need to ensure that legal aid providers can perform all of their professional functions, but they do not suffer or are threatened with prosecution, administrative, economic, or other sanctions for any actions that they take in accordance with existing professional duties, but also professional standards and ethics. So beyond the code of conduct, they may have responsibilities and duties as a legal aid provider that they wouldn't have if they don't deliver legal aid services. But if everything is standardized and then they behave according to these standards, then they can prove that interference with their work shouldn't happen because they are adhering to the rules that have been set by all the stakeholders that are important. And of course, safeguards that are essential in this regard should really include that there are mechanisms for complaints of breaches, because they can be brought before an impartial committee, and that can be established by the legal profession. And then they can be reviewed, and they can be reviewed independently. So the law that you are currently developing in Uzbekistan is, as far as we can see, the draft making very good use of these possibilities to include the Bar Association and hear their voice and have them have a say, but not only in the standard setting, because you also cover the practical quality assurance, and especially in Article 12 of that draft law, where you say, together with the legal aid body, we will participate as the Chamber of Lawyers in the monitoring and provision of the free legal aid. And we participate in determining the criteria for evaluating its quality. And also that together with this body, you participate in the monitoring of concrete activities, and you approve quality standards for the provision of such services, and you monitor the compliance of lawyers with these standards. So it's very important that this is really acknowledged by all the parties, and that the role that you have in order to service your members, but also the role that you have in ensuring access to justice for everybody and providing professional opinions that come from practice and that come from decades of practice and experience, that they are not only heard, but they also find their way really into the codification of the law and also of the. Thank you very much.
Thank you very much, Ms. Holterhoff, especially for your points about legal aid, free legal aid, which is very important. Davron, I think we've had an extraordinary set of presenters. They've given our participants a very broad view of the importance of the bar and bar associations. I will turn the podium over to you, Davron. We have a few minutes, I think, for questions and answers, and we have a very active set of questions that have been raised in the chat by our colleague, Mr. Nadiri, who's a member of the Leadership Council and an attorney from Afghanistan. But on behalf of Regional Dialogue, I express our thanks to each of our presenters and to you, Davron. We think this was an extraordinary roundtable. So, Davron.
Спасибо, Джеймс. Мы, конечно же, обязаны соблюдать.
Thank you very much, James. Of course, we have to observe the time limits. We will have only 5 minutes before our roundtable ends, and all the presentations by our speakers were informative and very comprehensive in the experience of our colleagues from Western countries and from the post-Soviet space. Deserves close attention and analysis. We will continue to review that experience and to interact with our colleagues as for questions and answers. So since what we cannot discuss at our roundtable, and the questions that will remain unanswered, we can ask the questions using the addresses, links we will post on the website of the Chamber of Advocates, so everyone can have an opportunity to ask their questions. But since now we have some time, please ask your questions. I will give Jamshed Turdaliyev an opportunity to read the questions. Thank you, Davron. We got a question from Mr. Nadiri.
region. And I'm sure this conference is a first step. And what is the role of UNODC in the pretrial release? And what are your activities regarding alternatives to imprisonment and imprisonment? Да, господин Надири задал вопрос касательно возможности.
So Mr. Nadiri asked a question about an opportunity for interaction among regional bar associations, and we, the Bar of Uzbekistan, we are open to that. And you are aware that in 2018, for the first time, the conference of the Chamber of Advocates was organized, and our neighbors, representatives of all countries of the region, came to that conference, and that was the very first step to strengthen the mutually beneficial cooperation with our neighboring countries. And Mr. Nadiri gave his contact information, and we will give them to our international department, to our agency, and we will be happy to cooperate on all the issues that may arise. Also, we would like to thank all our participants and each speaker, and Annika, Maria, Yuri, Sergeyevich, James, and everyone who participated in our session, and those whom I not mentioned, and everyone who is raising awareness of the law in general, doing extensive work in this regard, and educational activities in our country. Well, all of these activities always benefit the legal community in our country. Thank you so very much. Now I would like to give the floor to our moderator. Dear colleagues, definitely the advantage of such format of meetings is evident to everyone. We believe that not only under this forum, but in addition to this annual event, we would like to have such meetings on more specific issues, like advanced training for advocates, issues pertaining to activities of disciplinary and qualification committees, and issues of protecting rights of advocates. All the issues that have been outlined by previous speakers, they require further focus, further analysis, and sharing experience. Like what mechanisms are in place, what mechanisms of them are effective, and which mechanisms failed to perform their functions. And in general, I can say that the goals we have set before us at this roundtable have been met, because I could see that our colleagues made a lot of notes of the presentations by our speakers, and by the 1st of July 2021, we will have to develop the draft law on the bar and activities of advocates, and it will be a direct document which will include all legal and regulatory documents regulating the activities of advocates. We plan to carry out this work in close cooperation with the Ministry of Justice, our foreign colleagues, other government agencies, and we do hope that at the next Tashkent Law Spring Forum, we will have an opportunity to present how this law is enforced in practice. And we will recall this roundtable, and we will see that the provisions, the ideas voiced by our colleagues have been outlined and included in our new law. Thank you everyone for being part of this event. I would like to thank the organizers. I would like to thank the interpreters. Special gratitude is expressed to James Eaglin for facilitation it really helped our speakers express their ideas, make dynamic presentations, and hopefully together with James we will have a lot of events in the future. So all participants are invited to the Republic of Uzbekistan, and we hope that the problem of COVID will end soon. So this is the year when we will vaccinate all those who are not saying COVID is non-existent, and it will also produce the positive effect, and hopefully our countries will be able to establish not only online but also offline communication. Thank you very much.